right, it's 7 o'clock. We're going to call the meeting to order. Thank you for everyone for coming. First order of business is to take actions on the minutes of March 13th, 24. I do have a modification that I'd like to suggest under public hearings. It says Jay Ladati recused himself from all proceedings regarding this application, however, received permission from the commission, public, and applicant team to continue to run the meeting. That's not really accurate. I basically recused myself from all deliberations and intended to continue to run the meeting. Although no one objected, we didn't take a vote on it, so I think it's not accurate to say we received permission from the public. So I would modify it to say Jay Ladati recused himself from all deliberations regarding this application, but will continue to run the meeting or chair the meeting. I think that's a more accurate description. Okay? So I'll entertain a motion to approve the minutes as amended.
So moved.
Dave Coley, second?
Second.
Further discussion? All in favor?
Aye.
Opposed? All right, I'd also note, I should have noted it right away, Vicki Dorenzo is attending this evening via that big screen up there. So she's in attendance. All right, so. And I just ask everyone to keep their voices up. There was an inquiry at the last hearing by Ms. Everly because she was having trouble hearing. She inquired of the first selectman. There's no audio supplement here. There's no loudspeaker. So if we could keep our voices up so everyone in the room can hear all of the comments, I'd be appreciated. It would be appreciative. It would be appreciated. I'm sorry, it's been a long day. It's about to get longer. I would also, again, I've asked people to limit their comments to 5 minutes. A lot of you in the audience I know have spoken before. So, and we do have, those comments on record. We do not need them to be made again. And again, I'd ask everyone to bear in mind that this is a public hearing. All communications with the commission have to be done in this context. There have been some people have tried to reach out to various commission members. It's not allowed. We've explained that. It all has to be done in this forum, just so the public understands. The commission cannot have meetings outside of this forum. So everything needs to be done in this room. Okay, so let's start with the first agenda item, A37 Hartford Avenue. Vessel Real Estate Holdings, LLC, and Vessel Technologies, Inc., permit application for regulated activities in connection with the development of a 42-unit apartment building. This is a continuation of the public hearing. First hearing was on February 14th, and the second one was at the last March 13th, 2024. So we'll start with the applicant, Attorney Hollister.
I'm sorry, point of order, Mr. Chairman?
Sure.
Shall I approach?
Yeah, please, and identify yourself.
I will. My name is George Schober. I'm an attorney from Summers with the firm Schober & Schober. I represent Peter Voskowski, who is here with me tonight. I noticed in reviewing and preparing for tonight's meeting that, Mr. Chairman, you have asked on a couple of occasions whether or not the public had an issue with you chairing the meeting, even though you were recusing yourself from the deliberations. And I'm wondering if there is some sort of conflict. I'd like to be able to knowingly and intelligently advise my client as to whether or not, if you are still asking whether, the public consents, whether or not he should consent or not. But I don't know what the conflict is. I couldn't discern that from any of the record.
Mr. Sobin, as an attorney, you would understand this. Schober, you would understand that I can't disclose any client confidentialities or relationships, professional relationships with any people in this room. But I can indicate for the record that the reason I've recused myself is that I have professional relationships with some of the public in this room who have strong opinions about this application. and to avoid the appearance of impropriety or to raise any issues that the applicant may raise about a conflict of interest, I've chosen to recuse myself from deliberations.
My client, we've discussed this, what the possibilities might be, and under those circumstances, we have no objection to you continuing, sir.
Thank you for understanding the confidentiality aspect.
Oh, absolutely. I wasn't looking for names. I just sort of needed the circumstances.
Sure, thank you. Mr. Hollister, you have the floor again.
Thank you. Good evening, Chairman Ladati, members of the commission, ladies and gentlemen, town staff. I'm Attorney Tim Hollister, representing the applicant. One housekeeping item, I gave to your clerk a copy of the resume of Sigrid Godwin, who works with Mr. Logan at REMA Environmental. And all I'm going to do at this point is let our team members provide updates and final responses, most of which you already have in writing, but before we close the hearing. And I'll start with Mr. Levy.
Thank you, Attorney Hollister. Thank you, commission members, for allowing us to present this evening and for having us. I know we've taken up a lot of your time already, so I'll try to be as quick as possible while going through any of the remaining questions. And of course, our team is here to answer any questions you may have as well. I'm joined tonight by Sigrid Godwa, who's a certified ecologist, a registered soil scientist, and a wetland scientist, by George Logan, a registered soil scientist and certified wetland scientist, and Jim Sipperly, a certified wetland scientist and the environmental planner for the city of Middletown and the staff member to their Wetlands Commission. I want to start tonight by just trying to contextualize, what we're talking about here tonight. Ultimately, what we're talking about here tonight is whether there's any adverse impact to a wetlands or watercourse that should prevent the creation of 42 homes for people who need and want them, who want a wonderful place to live, who deserve a wonderful place to live. And, obviously, one should not outweigh the other. But given the circumstances, if there's not an adverse impact, I would hope that everybody would be enthusiastic about the idea of providing people with high-quality homes that are safe and sustainable and healthy for them. I'd ask you to change the slide to the two slides, actually. So, today we have this site. It's been like this since about 2007 when the initial approval was provided. Just to remind everybody about, if you can go to the next slide, what the initial approval was in 2007. This is what it was. And you can see here that the approved plan actually is much deeper into the upland review area, provides much more of a significant impact than the current plan. The current plan is actually in a narrower envelope and provides less impact on the existing upland review area. This is shown in the next slide where, the site plan with the regulated area, as you know, there's no direct impact or no direct work that's being performed on the wetland. We are only in the upland review area. There will be no activity in the wetland area or anything that is near the wetland area. You can go to the next slide. Just as a reminder, as part of what we're doing, there's an extensive landscaping plan that that Fuss and O'Neill presented on. This landscaping plan will provide a buffer to the upland review area as well as to the wetland area and improve the overall ecological environment of that area, providing a net benefit as opposed to a negative impact. So we can go forward a couple slides. Oh, sorry. So, just to talk about adverse impact. So Mr. Logan, Mr. Sibley have all provided testimony already. They've all been on record. They've provided written testimony as well, that there is no adverse impact to the wetland by the proposed activities. This is been consistent throughout their testimony. It started with the December 10th letter from Mr. Logan, where he said the receiving wetland down gradient into the south of the proposed septic system has an exceptional capacity in attenuating nitrogen to concentrations that would not adversely affect the regulated resources, including the west branch of Salmon Brook. Mr. Sipperly, starting in June 25th, 2023, came to similar conclusions, both of which unequivocally stating that there would be no adverse impact to the wetland. And per their commentary, in terms of any hypothetical impacts, they said that there's no even hypothetical impacts on this wetland. The idea that nitrogen can damage a wetland is different than nitrogen damaging this wetland. And so the content of their testimony is focused on what is this wetland. And this wetland, as defined by Mr. Logan, is a red maple swamp with high abilities to attenuate and address nitrogen. And, in all cases, Mr. Logan has, been very clear about the fact that the level of nitrogen at 7.7 mgs per liter cannot have any adverse effect on the wetland itself. To focus on specificity versus generalities, I think we've heard a lot of testimony throughout this process, a lot of commentary from Dr. Danzer as well as from others about potential impacts to the wetland. We've provided the board with, 3 experts, all of whom came to the same conclusion. They didn't come to that conclusion based on a hypothetical assessment of the area. They visited the site multiple times. They performed soil testing. They performed water testing. Where in contrast, Dr. Danzer did not perform any of his own individual testing, nor did he visit the site. Everything provided in Dr. Danzer's commentary has been to the extent that a nitrogen level could have an impact on a wetland, or may have an impact on a wetland. May is not a definitive determination with respect to wetlands and what governs the basis for wetlands determinations.
Mr. Levy, can you keep your voice up?
Oh.
Someone in the back just indicated they can't hear. Thank you.
Sure. May is not something that provides a definitive assessment of, damage to a wetland. And in fact, in one of Dr. Danzer's statements, he said, to quote him, "To provide some perspective, the level of impact is now more in line with projects in other municipalities that I've reviewed, of which have also been subsequently approved." But the focus of what I'd like to say in terms of specificity is that, the idea of saying things like notably less impacted or more in line with other projects, even those things are generalities. And whereas Dr. Danzer has said things very generally, our scientists and our experts have been very specific in terms of what they've said, which is because of the types of soils we have here and the constitution of this specific wetland, the nitrogen will have no impact on those soils, on the wetland itself, or on the watercourse. Just to go back and just to think about, what the wetlands regulations in Granby's and, prevailing court cases have said, the court has said that the only reason a permit or application, if it receives evidence that a proposed regulated activity can be denied, is if it receives evidence that a proposed regulated activity will have a substantial adverse impact on an existing function of a wetland or a watercourse. And then it goes on to talk about the fact that because these issues are so complicated, they require expertise, and the evidence must be provided by a qualified professional. And that professional needs to explain with quantity and calculation the specific location, value, and function of the impacted wetland or watercourse, and how will that be adversely affected. In none of the commentary by Dr. Danzer has there been anything about a quantity, a calculation, or a specific location or value that's going to be impacted by the proposed activity. There's just simply no evidence of an adverse impact at all to the wetland. Let's just talk about this wetland specifically. So in the information that we provided back in response to the different memos that have been provided that are in record, we spoke about the classification of this wetland as a red maple swamp. These soils are very poorly drained, have high organic content, and are seasonally saturated to saturated hydraulic regimes. The impact of nitrogen on this specific wetland that we're talking about must be based on that qualification and the underlying organic makeup. And red maple swamps, as we've provided previously, and Mr. Logan reviewed and has provided testimony on, have an extraordinarily high capacity to uptake, transform, and sequester nitrogen. This means that the output from the system is the other part of this is the level of nitrogen. So you may recall that in a previous application that we submitted, the nitrogen levels were much higher. They were above the 10 mgs per liter that are permitted for safe drinking water. Currently, we're at 7.7%, below that level. Just to sort of qualify that for what for people in terms of what you think about, what the state's saying there is that somebody could safely take a cup, pick up that water, drink it, and not get sick. So when you combine that idea with the fact that you have a specific type of wetland here in the form of a red maple swamp, and Mr. Logan's testimony associated with it, he's very clear about the fact that there's no way that there's going to be any damage to this. In our latest response, you'll see that he quoted what is, he says, the seminal monograph by Golay in 1993. It's called Ecology of Red Maple Swamps in the Glaciated Northeast, a community profile. And it talks about the capacity of the red maple to take out nitrogen in the groundwater, which is going to the fact that that is in fact its function, and that in no way are we damaging its function by virtue of this. So the next thing I just want to take it to address is the idea of pollutants. So throughout this whole process, we've been referring to different things as pollutants. Danzer in one of his memos goes through a definition that a pollutant is any substance introduced into the environment that may adversely affect the usefulness of a resource or the health of humans, animals, or ecosystems. He notes in this that an eroding stream bank could do this, an herbicide, an insecticide, even the waste of one of our family pets could produce a pollutant. So based on this, in terms of, we have all these naturally occurring, potential pollutants, the way that Mr. Logan tried to explain this in an earlier meeting was by analogy to copper. And what he said is that copper is an essential trace mineral and an enzyme cofactor. But what he said was also that depending on the receptor, what's receiving that copper, and the levels that that copper comes in at, it could become a pollutant. The same is true of something like nitrogen. It could, at certain levels or based on certain receptors, become a pollutant, but not when it is applied to this specific wetland at these specific levels. And that's what Mr. Logan has said during his testimony multiple times. The other things that Dr. Danzer noted is that a pollutant is something that may adversely affect the usefulness of a resource or the health of humans or ecosystems, but that's not the underlying basis for legal rulings by the courts. So per the court's ruling in Riverbend, which is cited in our responses, undocumented and unquantified claims without locations and claims of an unspecified increase in a pollutant or a potential for impact are not evidence of an impact. The term may refers just to that. It's unquantified and it's undocumented. Any claim of a pollutant is the basis for denial is incorrect based on that because speculation is not evidence. Furthermore, we talk about other things in these memos, but one of the things that is to note is that by referencing the idea that that nitrogen is a pollutant, and then giving definitions of these other pollutants, including herbicides, insecticides, dog waste, essentially what that's saying is that everybody living in and around this wetland who is at any time engaged in either having a septic system, of which there are many surrounding this wetland, using an herbicide, for which they are not prohibited in the area, using an insecticide, again not prohibited in the area, or allowing their pets to go to the bathroom outside, potentially has created pollution in this wetland. So either the definition is correct and this wetland is irreparably polluted, or it's an incorrect definition because different things at different levels don't have a polluting impact, even though at a certain level, based on what's receiving the wetland, they could in fact be defined that way under different circumstances. So, that refers back to what we were just talking about earlier, which was the 2007 plan, which you can clearly see in this case is more extreme, more invasive into the upland review area than the plan that we, are proposing. So, to address nitrogen for a second. So, as we were saying, we're at 7.7 mgs per liter. Again, that means that the water is clean enough to drink without you getting sick by, state standards. The issue at hand in terms of whether, of all of this is really whether the level of nitrogen at this level on this specific wetland is damaging the wetland or creating an adverse impact on the wetland. And the statements by Mr. Logan, Mr. Sipperly, as well as all of what they've submitted as testimony and written evidence, is that there is no adverse impact. And in fact, in Danzer's own comment, when he refers to the fact that the levels of nitrogen are in line with other projects he has reviewed from municipalities that were subsequently approved, he's by virtue again saying that this is a safe amount of nitrogen for a wetland. The commission has to determine whether there's a clear and substantiated evidence that the nitrogen at these specific levels will create an adverse impact on the functions of this specific wetland. And the answer is that it will not at these levels. The Mr. Sipperly and Mr. Logan, who are here tonight and can, address any questions that you may have on this, have been very specific. They have specific training. They did specific testing associated with this. They looked at the soil itself and performed testing on the soil as well as the water again. And based on those specific analyses, can say that there's no adverse impact and that there's no issues associated with the nitrogen. The next thing is that there's been ongoing questions about whether there's a seep. We provided these in a separate, in a separate submittal. But just to be clear, Mr. Sipperly visited the site on many occasions. This is the picture near Wetland Flag 7 where the question of the seep were. These were clearly tire tracks. He went in and looked at these after rains as well as after, other events and came to a conclusion based on specific evidence and specific site visits to say that these were man-made tracks that were put in. This is in fact not a seep. Salmon Brook has come up a number of times as well. Mr. Logan has commented on this, already as well, but just to summarize what he said, the first thing is that Salmon Brook is approximately 2,000 feet away from the edge of this site, and will maintain its water quality and natural environment. What Mr. Logan explained is that the receiving wetland at the base of the slope is part of a huge riparian wetland system, and that's all comprised of these very poorly drained soils. And there's about 20 acres down gradient to the site that will naturally buffer the west branch of Salmon Brook and prevent any issues with respect to that. Mr. Logan also goes on to further explain that anything that is, getting to the water's edge where he did testing and explained that the current levels of nitrogen are about 0.94 mgs per liter in that water, that in his professional expert opinion, based on the type of wetland we have here and its capacity to attenuate nitrogen, that the worst case scenario when you reach that stream is 0.77 mgs per liter. And so you in fact will not be raising, you'll be below the current levels of nitrogen in that stream. Sewer, I think, has been the, another ongoing question. I think that the to avoid any argument about whether sewer is or is not available, I think we have, all heard and agreed that the fact that there's no currently sewer available at the site. There's not a sewer connection point at the site. We can't connect into the Rushford Mead development. And there's nothing where there's any plans to extend the sewer line. The discussion over whether CTDOT will or will not permit it in the future, while of course they were very clear in their email to us that they would not, which we provided to the board. Mrs. Kenyon, we received information back from them that they would of course accept an application and then make a determination at that point in time. That is of course always what they do. But to that point, you would need a fully approved application through planning and zoning in order to find out whether they would ever approve a sewer extension on their road. And in this case, there's no need for a prudent and feasible alternative associated with the sewer, given the fact that there is no evidence of a substantial adverse effect to the wetland or watercourse. There's been some ongoing discussion around the stormwater management system. Just to be clear, you're probably in receipt from comments from your town engineer, where he conclusively says that he is in agreement with Mr. Moran, bless you, that the design has met all the standards of the DEEP manual, that there's no issue with the geomatrix soil air system, that it permits the user to monitor how often the system is running and if there's ever an issue, that the design flow of the system is correct and was done correctly, and that the stormwater management system has been designed in accordance with all state and local requirements, and that it meets the requirements for the 25-year storm event and is using all of the correct infiltration rates. So, one of the things that we addressed earlier was, the ongoing public comment. We realize that, there has been ongoing public comment and consternation about the development. We understand that there are people who would prefer not to see this developed. That they would prefer not to have a multifamily building there. The reality is, of course, that is not a wetlands issue. That's a planning and zoning issue.
Mr. Levy couldn't hear what you said. Would you mind repeating it?
Sure. I said that there may be people who do not want a multifamily building at the property or do not like this particular development. That, of course, is a planning and zoning issue. It's not a wetlands issue. We understand it. We in no way would try to refute the way that people feel. Everybody is absolutely entitled to their feelings and totally reasonable for them to have them. The analysis, though, of the wetlands watercourse functions is a technical scientific topic, and therefore testimony from qualified experts is required to prove an adverse impact. And so while we're sensitive to public comment and to the way people feel, we would also ask that everybody again remember that ultimately, we're talking about 42 homes for people who would like to have a high-quality place to live and would like to be part of the Granby community.
Excuse me, at a point of order, when you bring in a planning and zoning comment like that to offset the environmental input that our citizens have put forward through this whole process?
I think if you don't mind, let him finish his presentation. You'll have an opportunity to approach the podium and raise that question. We don't typically have back and forth between the public and the presenter. It would turn these meetings into absolute chaos if we did.
Fine, sorry, thank you.
That's all right. Thank you.
So just to go back again, just to look at the applicable state law and Granby's own regulations, without going through the Riverbend decision again, but the idea is that a wetlands commission may only deny a regulated activities permit if it receives evidence that a proposed site plan will cause an adverse impact to an existing function of a wetland or watercourse. I proffer to you today that there has been no evidence of an adverse impact. There's been statements associated with generalities about wetlands in general, but all of the evidence that is specific to this site has been stated by Mr. Logan and Mr. Sipperly, which is that there's absolutely no adverse impact on the wetland or watercourse. Again, that the analysis of a wetland or watercourse it must be based on testimony from a qualified expert to prove an adverse impact. Again, we do not believe that any adverse impact has been shown. In fact, to the contrary, we think that, it's very clear that there is no adverse impact on the wetland. Finally, additionally, that any evidence of an adverse impact must be site-specific. Experts must specify where and how the wetland or watercourse function will adversely be impacted with supporting data and calculations. Conversely, undocumented and unquantified claims without locations and claims of an unspecified increase or potential for impact are not evidence of an impact. A claim that any increase is a pollutant as a basis for denial is incorrect. Speculation just is not evidence. The only evidence provided about this specific wetland and this specific level of nitrogen has really been by Mr. Logan and Mr. Sipperly, who have very clearly said that based on the fact that this specific wetland, the constitution of the ecosystem there, that there is absolutely no risk of damage to the wetland or watercourse with this level of nitrogen. The final thing I'd say is that, just to, restate, I guess, what I was saying before is, there hasn't been any site-specific, data provided that there is an adverse impact. There's been questions about, will the stormwater system work? Will the solar system work? As in all cases with respect to the underlying law, the applicant is entitled to the presumption that we will operate the property in accordance with the rules and regulations of the town of Granby, and that we will do all necessary maintenance and other things in order to make sure that it runs correctly. And of course, we will absolutely do that. To do otherwise would be against our best interests. The development doesn't propose any filling or disturbance in the wetland or watercourse. All construction is outside the wetland and in small parts of the outdoor review area. Again, I think that it's clear from all of the information provided that there's just no adverse impact on the area. So that's all I have this evening in terms of my comments. I know that Mr. Logan wants to provide one bit of more information, and if you have any questions, we're happy to answer them. Thank you.
If I could just, for a moment, and I don't know if you're the appropriate person to ask, but we continued the public hearing at the last, from the last public hearing at your request or your attorney's request. And the minutes reflect it was for two purposes. One, to provide commentary, which you've done to all of the things that were raised at the February 14th hearing and the March hearing. So you've summed up that pretty well, but there was the second part of it was to, what the minutes suggest to me was so that the septic approvals may be provided along with the responses you just gave us. Can you just tell us what's going on with the approvals?
DPH has asked for some additional testing below the site in the upland review area for the septic system on the hill.
Soil testing.
For additional soil testing in that area.
Yep.
They just got back to us with that request. Of course, we will comply with whatever request they have, but they want to see additional testing before they finalize.
So you don't have an approval from Connecticut DPH?
Yes, ma'am, that's correct.
What type of soil testing do they want to do?
It says-
Perk testing.
Yeah, it says additional soil testing is needed in the area down gradient of the proposed leaching system.
We want additional perk testing, 25 feet below the system.
And I have one other question. So at the last, I may have misunderstood Mr. Hollister, but my understanding was that at the last hearing, that revised plans had not yet been submitted, but were about to be submitted. Have the revised
They were
plans?
submitted, yes.
Do you know when they were submitted, Mr. Levy?
The final revised set was submitted April 1st, along with updated, which were sent to the town, as well as updated radon nitrogen calculations at that time as well.
But there still are no approvals in place from any of
That's
them.
correct. They still want additional perk testing.
Is the soil testing going to have anything to do with nitrogen testing?
No, they were very clear actually in their statement that they asked, for instance, why we were using the solar system, because they did not know it was an issue. We of course explained that we were doing it to be sensitive to the wetlands and watercourses, so we would diminish the wetlands, to which they said, very well, we have no problem with you doing it, we just don't know why you're adding this to the system. But there's no testing associated with nitrogen. All they care about is the percolation rates. To make sure
Soil
the
air,
tanks are
that's what he's talking about.
I got another additional comment based on what was just discussed. My name is James Sipperly. I'm a certified soil scientist. The Department of Public Health, they are a independent third-party agency that has their own specific jurisdiction and regulations and state statutes that they are governed by and that they follow, completely separate from this commission's duties and responsibilities as far as wetlands protection and state statutes. So there's no reason why their decision would hold up the commission's decision on this application. I mean, if there's going to be a decision that's going to be made later on or some kind of a finding, and it's required that the applicant will have to modify something in the future, the commission will certainly come back in front of the commission with a modification of such changes, if there are any. So I just wanted.
I just have a quick, so if we don't have the final septic plan and it's not on record with us, and the approval, disapproval, or modifications is not on record with us, how does the public have an opportunity? What if they wanted to have their expert review that?
Oh, that'll come back. If there's changes, okay, so they do the additional testing.
Yes, so just to be clear, you have the latest septic plan on file that's been submitted to the town, submitted to the.
April 1st.
Correct. Along with updated nitrogen analysis. And I think what Mr. Sickley was saying is that any change to that plan would require us to come back and essentially submit for a modification.
Correct.
At which point we would be able to.
Reopen the public hearing and have the comments,
Backwards.
yes.
Yeah, it does seem a little
backwards.
backwards.
Definitely seems,
Yeah.
But again, I mean, I've been doing this for a long time. And attorneys and other jurisdictions, my wetland commissions were always told, you can't hold up your decision based on another agency's decision like the DOT or.
but you haven't got your permits.
Huh?
You haven't got your permit.
Well, we can't do anything without the permit anyway.
Right.
So your failure to obtain the permit for BPA.
Putting the cart before the horse.
That could be in a condition of approval, that happens all the time. I mean, you can't hold up your decision based on another agency. But what you can do is you can condition in your approval that a requirement that a permit from the Department of Public Health will be obtained prior to start construction. It's simple as that, but legally, I'm, okay.
Your point is, we understand your point that, obviously,
I think there's I sense there's a certain level of frustration on the part of the commissioners because we had an application. I wasn't even involved in that one. There was several public hearings. This was continued, hoping that we'd have approvals in place. Now, so that was 6 months. Now we're on our third public hearing.
Yeah, no,
These are all volunteers.
I agree. Listen, I share the frustration too. We have, as you probably know, when you do septic testing, you have the agent in Department of Valley Health District come out for your septic testing, for the perk testing. We had them come out more than once, 2 or 3 times, because there have been changes to the septic system multiple times to address the the nitrogen. And they have never asked for this testing at the downgrading 20 feet below. That was a new surprise for us. We share the frustration, understand yours, and apologize for it.
Did I raise any questions for anyone else?
Well, raised a lot of questions.
Okay.
I'm uncomfortable with that.
Okay, well, Mr. Logan, I think you were next. Let's try to get everything into the record.
Certainly, I'm next. Hello, everyone. Good evening again. I'm sorry that I missed the last meeting. But I did, by the way, hear the verbatim testimony, read it through, because Dr. Danzer had been asked a few questions, and I looked at his answers. Not going to comment on those, but what I wanted to do is to qualify a statement that this gentleman did, because I think you need to hear from the experts. Now,
I'm sorry.
okay. We were just discussing, Mr. Sipperly and Ms. Gallo, who's also a qualified expert. That's what we put her resume in. We have 98 years of cumulative experience between the three of us. And I'll tell you something else which is also interesting. That the last application that was put forth before this commission, before it was withdrawn, your planner called me to be your third-party reviewer. And I gave her Dr. Danzer's name. Interesting how these things work out. Anyhow, so what I wanted to do is to present to you just one copy of this Ecology of Red Maple Swamps in the Glacier to the Northeast, the community profile, which is it's a monograph basically on red maple swamps in Connecticut, in the Northeast, in the Glacier to the Northeast. I'm a little biased about it because two of the people that are the primary authors were professors of mine at the University of Rhode Island. I wanted to read you a few excerpts. It will only take a couple of minutes, because I want you to see that what we've been telling you all this time is documented truth from probably the best paper you can find about red maple swamps in the Glacier to the Northeast. All right. And I'll give you the one copy. And there's 138 pages. I only have a few pages that I'm going to give you. It talks about organic decomposition and nutrient cycling. It does say what we've been telling you, that denitrification is the biochemical reduction of nitrate to nitrogen gas. So that's in there. It has a nice little picture about nutrient cycling, which is a natural process. And then there's a section called water quality improvement. And I did quote a little bit on the last little thing that we gave you and some of the responses, but I just want to read you this little paragraph and then another one. Groffman et al., again, one of the professors at the University of Rhode Island, demonstrated that denitrification rates were significantly greater in poorly drained soils of red maple swamps than in well-drained soils of adjacent upland forests. In a second Rhode Island study, this is the one that I quoted, Gold and Simmons, 1990, found that the removal of nitrate from groundwater generally exceeded 80% in both poorly drained and very poorly drained soils of red maple swamps throughout the year. Okay, here's another quote. Talking about these two studies. Both studies concluded that forested wetlands are likely to be more effective than upland forests as sinks for nitrate. Prolonged anaerobic soil conditions and high soil organic matter content appear to be mainly responsible for the greater denitrification potential of swamp soils. At the same time, high water tables bring groundwater contaminants closer to the surface where they can be picked up by plant roots. And a final quotation. In a 2-year study conducted in southern Rhode Island, Gold and Simmons, again, the paper that I quoted, 1990, injected a spike of nitrate, copper, and a tracer into the ground upgrading from forested upland and red maple swamp monitoring stations at 3 sites. They found complete attenuation of copper in the groundwater at all stations. Nitrate removal ranged from 14 to 87% in the forested upland, where soils were moderately well drained or somewhat poorly drained. In the swamp, it was almost complete, meaning the attenuation was almost complete in both poorly drained and very poorly drained soils. The highest attenuation occurred where groundwater levels were closest to the surface, which is exactly what's happening in this particular swamp, which, as I said, we have a seasonally saturated and saturated hydrologic regime, which means the water is either at the surface or very close to the surface.
So, George, just so that everybody understands, because we're not all wetland scientists and this is all technical.
Oh, why not?
Sorry. I said, George, just so everybody understands, because we're not all wetland scientists and don't all understand papers like this, is what you're saying is that this paper is specifically speaking about red maple swamp. Based on your analysis of the area,
Yes.
the wetland in question is a red maple swamp. And a red maple swamp has a specific function, as well as one might call it a superpower, in that it provides extraordinary denitrification and cannot be damaged by the level of nitrogen that we're talking about associated with this system.
You got it.
So what I
That's
hear
what
you
we're
guys saying
saying.
is that you want to use the wetlands to process the nitrogen.
We're not using the wetlands.
Well, you just said that, didn't
process.
you? You just went into great detail to explain how the wetlands will be used
Yes.
to process
It's a natural
the extra
process.
Well,
nitrogen.
we're saying that.
It's a natural
We're saying that
process.
wetlands
Right.
like these naturally denitrify.
Okay, right.
So what
Yeah.
what you folks.
So
are
you're
getting
saying
is-
you're going to use the wetlands to denitrify the waste that you're pumping into the wetlands. That's what you just told me.
What
Am
you
I
should
wrong?
be interested is whether or not this particular wetland will suffer adverse impact
Oh, there
from
is an impact.
receiving the.
You just clarified there will be an impact. Because
No, I
you're
did not
pumping
say that.
nitrogen
You're
into the
putting
wetlands.
words into my mouth.
No,
I
no,
did
you
not say
said
that.
you're putting nitrogen into the wetlands, and the wetlands will process the nitrogen.
And that
Yes.
and that doesn't.
Without an adverse
That
impact.
doesn't say that there's.
No,
an adverse
I don't
impact.
think you can say that.
Of course you
Of
can.
course
That's
I do.
exactly what he is saying. He's saying that because of this specific wetland within the constitution of this.
Let me-
There will be an impact. Adverse,
An impact,
No.
an impact is not an adverse impact.
it is an impact.
Those are two different things.
Are they though? Because we're saying,
Sure.
will there be an
If
impact?
somebody- if
Will there be an
If
impact?
somebody shows up to your
Will
house
there
for
be,
their
an
birthday-
yes or no? Will there be an impact?
I can't answer that, that's for Mr. Logan.
You just explained to me there would be an impact, that the
But what I'm
wetlands would take care of
What
the
I'm saying is
nitrogen.
this.
It's not an impact.
You're talking about an
Well,
impact.
what is it then?
It's natural nitrogen cycling that happens.
Which wouldn't
all
be
the
there.
time.
If the nitrogen wasn't pumped into the wetlands, there wouldn't be a,
Okay.
what?
So let me explain.
There wouldn't
something.
be a what?
Let me explain.
Don't
something
explain it to me, answer my question.
I need to explain it to you.
You don't have to explain anything.
Well, then I won't say anything.
You've explained so much. You've been explaining for a year. I've asked you a question, and you're not answering
Do
the
you
question.
want to know?
One at a time. No,
Explain
please,
explain
please.
what I asked you.
Please.
You're trying to tell me that natural nitrogen cycling in a wetland is an adverse impact.
No, I'm saying there is an impact.
There is not.
We don't have to say adverse impact. Is there an impact or not?
No,
Are you using our wetlands to dispose of nitrogen?
there is not an impact.
Are you using
Did I just
our,
read you something that says complete attenuation?
are you using the wetlands
No,
to dispose of nitrogen?
no, we're not.
You just said you were.
If you let me explain a little more. So it's a natural process. In this particular situation that we have here, this red maple swamp, which has a large watershed, what happens is that there is nitrogen that's naturally coming into the system. This is what Dr. Danzer said.
But this is not naturally occurring nitrogen.
Could you let me finish?
I've let you finish. I've listened to your entire thing. You read us from the journal and everything. I've been sitting here for it, haven't I?
And I'm trying to explain it to
And
you.
you've explained it to me. And I'm asking you a simple question.
And I'm saying it's not an impact because it's a natural process. So the system responds. There's multiplication of microbiota, which naturally will multiply and take care of this particular.
Which wouldn't be happening if it wasn't there.
But it happens all the time.
But not in this situation.
Sir, you need to let me finish and not
I let you
this
finish.
conversation.
In fact, we've let you finish so many times. We've continued this for months.
Excuse me, point of order. Can we move on here?
There's no point of order, sir.
Commissioner,
You're not
All
doing a
right,
good
let's,
job.
Oh, you come and help you.
okay, let's not have arguments between the audience the professionals, the commission, let's try to keep it, one person talks at a time, okay? Mr. Logan is not prepared to answer any more questions
Commissioner, I understand.
on this point.
Sorry.
Thank you, I appreciate it.
Eat the first.
Commissioner,
I think it's a circular discussion that we could have for the next 20
I
minutes.
understand. It's a circular discussion. The only thing I would say is that I think where you and Mr. Logan are at odds about is his version of a scientific impact and your definition of an impact. And what I was saying is that we have impacts in our life every day. If somebody shows up to a surprise party for you, you're impacted by it. Of course, you may be pleased. That's an impact. It's not an
Okay,
adverse.
well, I'll tell you where I'm not pleased. I'm not pleased to see that our wetlands are being used to dispose of nitrogen. That is not part of the natural ecosystem, and that's what you told me tonight. And you went into great detail, right? The two of you went into great detail about it in this final moment here. And there's no.
And that sewer is not part of the natural ecosystem.
We've been begging you for months. to
Nitrogen
look
that's
into-
coming out of there is
You proposed today that there's no
Not-
way you're
not
hooking into the
natural.
sewer.
One at a time, please.
I guess I need to answer this, but I'm not black to answer.
Go
this.
ahead and answer it.
Dr. Danzer made a comment in his last report. He says there is endogenous nitrogen and exogenous nitrogen. Do you remember that?
We don't have to go into detail about the Danza report. I've read it 5 times. The fact of the matter is, you've told me that there will be nitrogen pumped into the system that has zero nitrogen
Is
now.
it a yes or a no?
That's exactly the question. Is it a yes or a no?
I'm asking
Will
you
there
a
be
question.
nitrogen?
All right.
Will
This
there
is
be-
not, this is
Will
not
there
going
be
anywhere.
extra nitrogen put into the system?
Extra nitrogen is coming into this wetland right now from its
Okay.
watershed.
So yes.
From impervious surfaces.
The answer is yes.
It happens naturally. You live,
Right.
your nitrogen is going into a wetland or a water course.
To be specific,
Okay,
though, you're saying you don't like the idea that any nitrogen is going into the wetland, but, just point.
The nitrogen and other items, we don't have to get stuck on the nitrogen. We don't need to use our wetlands to dispose of things that we don't need to have an impact.
So, Commissioner, I would just say this, is that the 2007 plan would have had the exact same impact.
I wasn't here in 2007.
I understand your point and your position, which is, wetlands should be left completely alone. And, anything that you do to them is by virtue of that negative. It's just not the definition, as we would say, not to be argumentative, but under the law with respect to.
That's just not true, though. So,
this is
just your opinion.
we deal with impacts all the time, a tool shed, right? Versus 42 apartments. There's a little bit of a difference. Do you agree?
It depends on the circumstances.
Okay.
Meaning, the 42 apartments are not in the wetland at all. So if you were saying putting them in the wetland, then I would certainly agree.
So but you're still using the wetlands. All we've talked about is using the wetlands to mitigate, right, the impact of what?
Wetlands are always used as their purpose and function, meaning what Mr. Logan was saying and what he was trying to express is that the wetlands are being used right now in all material respects, that any runoff from anything surrounding that wetland that's going into them is using the wetlands. And what he's saying is that, there is no adverse impact.
We're supposed to sit here between and mitigate, right? So if we're supposed to mitigate, and there's another option, correct?
What's the other option?
A sewer option.
You have to come to the conclusion as whether there's an adverse impact. That's what the law says. Okay, because your footprint has an impact right now. Did you know that? On
So
the
there is an
environment?
adverse impact.
No, I
That's
didn't
what
say
he said. He
that.
said there is no
There is no
adverse.
adverse impact. You might want to call,
But that's your opinion.
No, that's his expert opinion.
it's my,
Oh, I'm so sorry. It is your expert opinion.
And it's based on testing of the wetlands, the soils, and the water.
sir, I've been doing this for 35 plus years. I have an education. I've been doing this for a long time. I act as a peer reviewer for commissions like yours all the time. I just did it in Naugatuck. I'm doing it in Middlebury. This is what I do. I live and die with the science. And what I'm trying to tell you, this is the science. So if there's a 90% attenuation of the 7.7 milligrams per liter of nitrate in the system by this wetland, coming down to 0.77 milligrams per liter, which is less than what we tested in the watercourse, which is 0.94.
But it's still
Which-
more.
It's still additional.
No,
No, it's
the concentration is less.
It's less than what currently exists.
You can't have something and add something and have less.
Because you don't understand how the wetland responds. If you put more nitrogen into the wetland, forget the adverse impact, it responds by taking up and soaking and becoming a sink. Trees grow, microbiota multiply exponentially and take care of this nitrogen and make it into nitrogen gas. That's what happens. Now, you can tip it, you can go over a particular threshold, then you have an adverse impact. But I'm saying that's not happening here. It's as simple as that. I can't really.
Excuse me, for the record, my name's James Sipperly. I'm staff to the Wetland Commission in Middletown for a long time. There's impact, there's adverse impact, and then there's significant adverse impact. The commission has to determine, it's in your regulations, you can look it up. You have to determine if something is going to have a significant adverse impact. If you make that determination, you can deny it. But you have to make that determination, a significant adverse impact, not adverse, significant adverse impact. And when I write a motion for approval, I write all these findings of fact, and then I say at the very bottom, this activity will not have a significant adverse impact on the adjacent wetlands or watercourses. That covers the commission's jurisdiction. That's what you guys have to determine. Just, it's in your regulations, just.
Thank you. Thank you, Mr. Logan. Thank you, Mr. Sibley, Mr. Levy. You're done. Anyone else for the applicant? The staff want to comment at this point, or do you want to hear from the public first?
I can comment, yeah, real quick.
Loudly, Cameron, so we
Yes,
hear you in the back of the room.
absolutely.
Because people keep grabbing their ears and going like this.
Yep. So I just had a couple of questions. I see Mr. Moran is not here from the applicant's team tonight to speak on the design or on the septic. I'm not sure if anyone else can comment, but I did have a quick question regarding the nitrogen calculations. So I saw on the plans that 150 gallons per day was used for the septic calculations, for the septic calculations, but 100 gallons per day was used for the nitrogen calculations in that sheet that was provided by Mr. Moran. I was just wondering why there was that difference in the actual output being used for the calculation of nitrogen output. Per my math, it was, and I unfortunately did not write it down, but I believe it was still under the safe drinking water level. I just wanted clarification on that. I'm not sure if anyone can speak to it.
The calculations used, as was referenced in your town engineer's response to the calculation questions, were in accordance with the standards for the state of Connecticut as well as the standards for the town of Granby, and he in fact said that the calculation was done correctly. Why one uses 100 versus 150, I can't, tell you that specifically, but I can tell you that it was done in accordance with the underlying rules.
Okay, thank you. And then I just wanted to clarify and throw out there again that per the email that was sent by Connecticut DPH earlier today, I believe, the septic has not been approved with the new revisions that were submitted on April 1st. The plan review fee appeared not to have been paid yet by the applicant. The additional soil testing was needed. The retaining wall sounds like it needs to meet minimum required separation. I'm not sure if that was a clarification on what the separation was or if they were suggesting that that needs to be moved. And then detailed specifications on said retaining wall need to be submitted as well. And then just confirmation on the soil air system. So I just wanted to throw out my general recommendation to the commission that, or I guess possibly not a recommendation, but just a summarization of the facts of the case so far. It seems like the applicant has done a good job of specifying that in their expert opinion, there will be no adverse impact to the wetland. Regardless of that, it seems that the plans that have been submitted to the commission have a high probability of being changed. Whether it's a significant change or not is up in the air. I don't think that necessarily the applicants themselves are able to answer that at this time, given the back and forth with Connecticut DPH, and then they have not received approval from Farmington Valley Health District either. And with that back and forth, while the commission could approve if they so chose, with the condition that that health approval is met, I think approving something where we know that the plan is going to change and we're not sure by how much may not be in the best interest of the commission or the town, and possibly not in the best interest of the applicant either, for then having to come back and resubmit fees to come back through the process for a permit modification that is expected, rather than something where it's approved and that's the plan that is being proposed to be stuck to, and instead they have to come back for modification due to unforeseen circumstances. So if anyone has any questions on that, please do let me know. But that's sort of my piece.
Did staff comments raise any questions for commission? Any additional, Fred?
Yeah, I had some additional comments, and it relates to this seepage at one of the boundary posts. I went out there today because, can I use the podium, get some pictures on there?
I don't know how you get pictures on there from the podium. You'd have to give them to, I think, someone in the back.
Can I do that?
We don't have the ability to do that.
Okay.
If you put it on the table right there, he might be able to zoom in.
They were up there before.
What?
Weren't those pictures up there before?
This one?
Yes.
Yeah, this particular picture, where would the table should I put it?
So we're in the meeting packet.
That one is. Yes.
That one's in the
That
packet.
was in
Okay.
package. Then we have some others.
Okay, so we can get that one.
This is the supposed tire mark seepage. It's been shown before, it was shown earlier. Basically, what you're looking at here, I'm not sure the date of when these were taken. They were taken probably a couple of months ago. But the camera is looking straight down at the side of it. I was out there today and on my camera looking at it, some other shots. And they're rather interesting. It's not what you see here. It's a lot worse. You have to forgive my camera, but.
You pass it around?
Yeah, I can pass them around.
Fred,
No,
just
bring
wait a
it.
minute. Let's see if we can get it on the camera.
All right.
Hold it up to the camera.
Where is the camera?
There's one here, there's one there, and one here, and one behind him. I don't know which one's I think. If you held it near it, you might be able to see on the screen. I don't know, I'm just guessing here.
Well, we need to see 1, 2, 3. If he's going to show something, the commission needs to see. Right.
Well, let's see if we can get it on camera, and we'll all see it at the same time.
Abby, I think the printer ran out of toner earlier. Oh, okay. Okay, got it. So Fred, maybe for the time being, you can just kind of describe what the picture was. And
Basically, looking at it from both heading in, I guess it's the easterly direction, maybe the western direction, on that farm road, there's a lot of water. It's coming, seeping out of the hill, rolling down, and going into the tire marks. Small, if you take a small picture like this, well, yeah, you can say, well, it's tire marks, and they pool. There's some pool. Yes, there is. But if you go out there, as I did this morning, there's a lot. It hasn't rained for the past 4 days. So there's a lot of it. And these pictures show where it's coming out of that hill. Not a very good situation from what I can see. So, hopefully we'll get something. That's basically all I wanted to show.
Fred, is that where the retaining wall is going to be?
What's that?
Is that where the retaining wall is going to
No,
be?
this is at the bottom of the slope, down by the farm road.
Okay.
Which was in the packet? That one.
That-
Can I ask Fred a question? That was today you went down there?
Yes,
We're supposed to get another 1 to 2 inches of rain on Friday, so it could be even worse than it was today.
yeah. Well, there's no question you've had soil. This is more than just pool.
Oh, no, it's a lot.
And it was a lot. And it's extended quite a distance from my picture shows. That's along that road. That's where the wetland starts. Yeah, and there's you can see like a small river, a couple of them come down, rolling out of the hills, creating that moisture. Maybe wanted to clarify what they were showing
Right.
as opposed to what's really there.
Have you seen those photos? Well, they're waiting.
That's what I'm
That's all I want. I use a CBS printer, it's not the best. Yeah, this is the one. It's showing
Yeah,
well.
that's all I can say.
Let's try to.
It just means a lot more work is after we pay for it.
I just think this needs to be looked into further. Because if it's coming out of there at that rate, that's a little bit scary to me. Unqualified as a scientist I may be.
Okay.
Okay?
Yep, thanks, Fred.
Thank you.
Anything else from the commission before we? Abby's here. Abby, did you want?
Oh, there we go.
Okay.
Okay, explain away, Fred.
Oh, okay. As you look up here, this is, like I said, this is the CVS printer. What looks like snow is water. That's water running all the way up there. And as you go up, this is heading west. You can see where it comes down out of the slope and even literally runs across the road and into the wetlands.
Fred, did you have pictures? Did you bring pictures today?
Yes, they're up there.
Yeah,
Those are the pictures?
those are the pictures.
Okay, so those are in the public record now?
Yeah, I would just
Okay.
scan them in.
Oh, okay, that's what.
And the
Thank you.
same, this is another one showing water that's running through there. Could you-
James Sipperly, again, for the record. You see the slope coming down. On record, right, in March, the amount of rainfall that we had in March is the second highest since 1909. Everybody has groundwater, high groundwater everywhere. That's a slope that is, when it rains, the water comes down the slope, right?
This is seeping out of the slope.
Well, it's going to be stormwater coming down the slope. It accumulates
And
in
it
those
crosses,
tire
you can
ruts.
see up further, this is looking
Those
west.
tire ruts look a lot rutted than when I visited those sites. I mean, it looks like that road's been used a lot, and it's a lot more rutted.
It's a farm road.
Who's using it though, I wonder?
Farmer.
Farmers,
Well, okay, there's no active fields that well,
Look at that, go 2/3 up that road, and you can see where it crosses over into the other
Yeah.
side, and that's coming off the hill.
well, I disagree with that because there's organic material right there that's being matted down by the vegetation, and there is topsoil there, and that topsoil and everything holds that water in those ruts. You can't go anywhere. I disagree that it's a seep. So,
Mr. Chairman, if I may, just sort of in the interest of fairness to the applicant, in their expert opinion, they did determine that the tire ruts were not seeps previously during, I guess, more normal rainfall conditions, and being in tire tracks for the most part, that's where a lot of compacted soil is, and so that means that the groundwater table is kind of perched and will not be able to infiltrate lower than those first couple inches of the topsoil. So just in the interest of fairness, it's very possible that this is just because of the tire marks just presented in the photos. I'm not sure if your on-site observations were different than that, but it looks like it's sort of just in the tire marks based on the photos I'm seeing.
No, as I said, if you look 2/3 up the road, you can see where it crosses, and that is coming from the hill, from the sun.
Okay, I see.
Anything else from the commission? Other than Mr. Sipley's comment in response to Fred Jones, anything from the applicant? We'll get to the public in just a minute. Okay. Abby, did you have any commentary at this point? I know you put in the record your correspondence back and forth with the DOT.
Director of Community Development. Yes, so in response to some information that was presented by the applicant regarding road work in Hartford Avenue and the ability to connect to the sewer, I just wanted to clarify for the record, and that is why I had the conversation with Ron Ferris at DOT on Friday, and then did get confirmation via email regarding where the public sewer ends at the intersection of Bank Street and Hartford Avenue. And while that intersection was repaved, it's not, as was, I believe, the conversation with the applicant, the connection wouldn't be at the intersection of Hartford Avenue and Route 10-202. It'd be to the east a bit. So DOT did indicate that it would be possible to, from the point of Hartford Avenue west to where new pavement begins, tear up from shoulder to the center, the double yellow line, and then where the new pavement starts to wherever that connection is made, it would be a full mill and repave. And of course, it is understood that with any project, they would want to see plans. But yes, that was the feedback I got from them, so it could be possible.
Okay.
And that email was included to the commission.
right.
Any questions about sewer?
The applicant has that email as well?
Yes, that was
Yeah.
forwarded to them, yep.
Yeah, there's an 8-inch stub at the intersection of Bank Street and Hartford.
Yes.
Okay.
That stub is 8 inches?
Yes.
Yes, and that was part of the as-built plan, which I think was part of the previous meeting packet, so it is on the record with that.
Okay. Any other questions for Mrs. Kenyon? No? Thanks. All right, I'd like to hear from the public. Who wants to come up first? Council? Again, just so the record's clear, please identify yourself and who you represent.
Good evening, Mr. Chairman, members of the commission. My name is George Schober.
Good evening.
I'm an attorney from Summers, and I represent Peter Voskowski, who is with me here tonight. And the first thing we'd like to do is to submit.
Point of order, can we just have his address, please?
Address is 53 Windmill Drive.
Thank you, sir.
He is the owner of the abutting property 39R, 39R Hartford Avenue. And the pictures with the tire tracks and the ruts, that's the farm road that my client uses. The wetlands are just on his property past that farm road, and then it goes down into the back, and that's where farming activities take place in other use. Trees are being grown. So the first thing that we wanted to do was to submit an intervention petition. I have copies for everyone, but I only have one signed original for the record, and I presume here. So this is the intervention petition for my client. Oh, I'm sorry.
Thank you.
You will note that there is on page 2 one change that has been crossed out and initialed, because when I drafted this, I was working from an older plan set in December where the leaching field extended. It was one row all the way across and went all the way to Wetlands Flag 7. And now in reviewing plans today, that I picked up the large sheets today, I see that it is, the leaching field is now 2 fields or two rows, and it's substantially shorter. It's just wider. So I had my client initial that one change. So we would ask that my client become an intervener. And the first thing
Excuse me.
Yes.
Just to confirm that the one that you gave to Renee actually is signed and verified?
Yes.
Okay. Because
Yes.
I mean, all ours are all blank.
They are, and that's what I'm saying. We can sign all 11 copies.
No, I just wanted to make sure that.
Absolutely.
Yeah. Okay.
Yes. Maybe we should have
on that application. I mean, he's in a butter, he has statutory standing.
He does, but it provides us additional rights.
We can hear them out and then figure out whether this qualifies or not.
Okay. So we'll do our presentation, which follows fairly closely what's in the intervention petition, where we will point out what the significant adverse impact will be, and in particular, what it will be to my client's property. So the first thing, though, we'd like to do is to address the seep that Mr. Jones was talking about, that he saw with his own eyes and I saw with my own eyes on April 1st. We have a video, and I'm going to ask my client to come up, and I'll ask him first if he took this video, and if so, when he took the video.
The video was produced yesterday.
Come on up, Pete.
Yesterday was April 9th.
Correct.
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 April 9th. Good evening, thanks for.
And where was this video taken?
This video starts out facing east, walking from just at the start of the proposed development, right almost at their property line, down on the farm road. If we could hit go. Okay. So I started walking. Now, just to let everybody know, the dry tire track in the previous photos you all saw were taken at the end of the extreme drought last summer, right before it started to rain. But as you see, what you see right here is pretty much 365, 24/7. This section of hill has always seeped, going back to when the original structure was on 37 Hartford Avenue, my grandmother's house. And it's only gotten a little better due to the parking lots and the grading that was done for this foundation that sits there today. A lot of the hillside was disturbed, trees were taken down,
And this water, yes, it puddles in my tire tracks. However, coming up here in a couple of seconds, it is trickling over and running into the wetland. And where it is trickling right now, as we speak, is within feet of flag number 37 on your prints, number 37. But that's constant. That's every day, almost all day, even in the wintertime. This swamp does not freeze. It steams. So the indication that, oh, we've had so much rain, well, we've had a lot of rain. We've had more. But this is normal. This is completely normal. I have been the steward of this property since I was 16, many, many years ago. My whole family's been there forever. This road leads out to my pastures. I grow clover, I grow beets, and I grow walnuts and chestnuts. And that's my truck. Now we're walking west. But as you can see, that is actually a little more than normal. But up right at the top of that photo, that is extra. That little grade of grass and the skunk cabbage is already coming up. Those tire tracks at the top of that photograph, that's not normal. There's a lot of water coming through the seepage and into that and then making its way down across to the left. And I invite all of you to take a field trip. You can walk right down a very dry road until you get there. And it's right below this proposed project. Thank you.
Now, the next thing that I would like to do is to correct something that Mr. Levy stated regarding who's been out to the property by way of experts. Mr. Levy stated that Dr. Danzer had not been on the property. But according to Dr. Danzer's October 25th, 2023 memo, he states that he was out there the week of October 16th. So he has been on the property. Now, my client is extremely concerned about septic effluent that is going to flow onto his property from this very enlarged, massive septic system. This septic system is very different from the 2007 septic system that was approved in the use. There are going to be 42 apartments with people living in them. And I would argue that at least half of them will have 2 people living in them. Even though they're a 1-bedroom apartment, you're going to get young couples, you're going to get older couples, you are going to get people that want a roommate to save money. You will get that. And so you are going to have at least 150 gallons a day being flushed down these toilets, down the showers, the dishwashers, and everything else. Completely different from whatever office/medical building was going to be built in 2007. Not comparable in the least. It's undisputed that effluent will flow from the septic system. Even the applicant doesn't dispute that the nitrogen will flow into the wetlands. It's just a question of what happens to it once it gets there. And the applicant says, and in fact, in the last memo the applicant submitted, it's a positive. Well, we don't think so. It's a negative. It's going to change the swamp. It's going to change the wetlands that are on my client's property. And Dr. Danzer states that more than once. So he talks about the adverse impact. He states that the introduction of excess nitrogen to natural wetland systems, such as that being proposed in this permit application, now these are my words, from the proposed septic system, back to his words, leads to changes in vegetative composition and species dominance within the wetland. My client does not want a change and the vegetative composition or the species dominance. He likes it the way that it is. He doesn't want the septic effluent trespassing onto his property. It will be a nuisance to him, and it will undoubtedly lead to litigation in the future. Now, Dr. Danzer continues. Excess nitrogen in wetlands favors faster growing and/or often invasive species such as phragmites and Japanese barberry. This is to the detriment of the existing wetland flora, which often is slower growing and better adapted to nutrient poor soil. The nitrogen is going to enrich the soil. Excess nitrogen, that was me, that was not him. Back to him. Excess nitrogen loading therefore puts the native flora at a competitive disadvantage. Wetland habitat quality is then negatively impacted through changes in species richness, number of species present, and species diversity, abundance of each species relative to the other species, when the less desirable species outcompete the native wetland flora. That is what's going to happen here. That is what Dr. Danzer says. He says it in a memo dated January 5th, 2024, which restates what he stated in his October 25th, 2023 memo. These memos are in the record, but that is the problem. That is the significant impact that you knew was happening. And that's where it is. And when you have 950 pages, or we may be close to 1,000 pages in the record, it's hard to find it. I usually don't get involved in these in the middle of things. I'm usually either at the beginning or on an appeal. It was a luxury to come in the middle, well, I guess, and review all 950 pages over the course of a week and watch your meetings. But everything was fresh in my mind. And so Dr. Danzer has also consistently stated throughout his memos that nitrogen from a septic system is inherently a pollutant. That's in his March 5th, his February 7th, his January 5th of 2024, and his October 25th of 2023. There will be a significant adverse impact to the wetlands. And I would urge that you deny this application, because we do have a feasible and prudent alternative, despite what the applicant may say. There is sewer available. It's in the sewer service district. What we've heard from the applicant are what I will call shifting explanations. And that's a term you usually see in the law with employment discrimination cases. When an employer wrongfully discriminates against someone, the first explanation shifts as things go against the employer. And that's what we have here, are shifting explanations. First, the applicant was told under no circumstances would the town permit this. Town staff told them no. Well, that wasn't true. It wasn't in the sewer service district. Well, that's not true. It is. It's 1,700 feet away. Well, that's not true. It's only 700 feet away. It's $900 a linear foot. Kurt Johnson put something in that said $175. It doesn't cost $900 to put in a new road a linear foot. We don't know how much it's going to cost, but cost is only a small factor in what is a feasible and prudent alternative. Your regulations have a definition of feasible and prudent. Feasible is defined in section 2.1 of your regulations. It means able to be constructed or implemented consistent with sound engineering principles. I guarantee you, this sewer system could be extended here using sound engineering principles. It is able to be constructed. Prudent means, according to your regulations, economically and otherwise reasonable in light of the social benefits to be derived from the proposed regulated activity, provided costs may be considered in deciding what is prudent, and further provided a mere showing of expense will not necessarily mean an alternative is imprudent. So we don't know how much it's going to cost, but we have 42 units to share the cost. I said the applicant should figure out what it's going to cost with real estimates and come back to you, and then you can determine, is it prudent? I don't want to hear $900 picked out of the sky. And here's another thing. It may cost $900 if you're doing 50 feet, because you have all that gear up to get that project going, all the engineering plans, all the mobilization and everything else. But as the length continues, those fixed costs are already in there, and each additional foot is substantially less. So we don't know how much it's going to cost. I can't tell you. You don't know. The applicant may or may not know, but they're not sharing it with us. My client doesn't know, but you know what? That's a number that can be determined. We do know there's going to be a significant impact to the wetlands, adverse impact, and we do know there's at least a feasible and alternative, prudent alternative that should at least be looked at, should be examined, because my client does not want this septic effluent flowing downhill onto his property. And he has every right to say, I don't want that. And you have every right to deny this application. It's incomplete, and it's not presented with feasible and prudent alternatives as your regulations suggest in 7.5. One other note, and I'm jumping backwards, but I'm not going all the way back to the beginning. And that is, I actually probably have more than one other note, but back in August 28th, there was a memo from Kate Bednarz, your former soil scientist, and she told the developer that it had to put on its plan set groundwater seepage was observed in the vicinity of WF7. Wetland Flag 7. That's August. And this plan, I got a copy today, is from September. It was originally from June, and it was revised on September 6th, and one of the revisions was this note. Now, if you look at the plans that were submitted on April 1st, this note is still there, because there is a seep, and everybody but Mr. Sipperly knows that. Every single person who's been out there knows what a seep is. It doesn't take a soil scientist to tell my eyes what's coming out of that hill. And any of you who have been out there, and anyone who hasn't, I suggest you take a look. That seep will still be there. You don't have to hurry out. It's going to be there tomorrow. It's going to be there next week. It's going to be there next month. I question anything Mr. Sipperly's told you when he says something like that, and he doubles down on it in the memo. That's all I have at the present, but I would like the opportunity to rebut should the applicant have further comments regarding this. Thank you.
Thank you. Does any of the commissioners at this point, before we go to the public, have questions for the council based on that presentation? No? Okay, good. Okay, let's open it up to the public. Mrs. Flanagan, Mrs. Everly, who wants to go first?
Roy Everly, Silky Road. I'm here presenting on behalf of Michael Fusick, who cannot be here. Done it before. And I think it's relative to bring it up now in light of what the attorney has said. If you'll recall, Michael Fusick works for MDC. He's a supervisor. He has a college degree. He has credentials. He's been with MDC for some time. This is in response, his response is in regard to what Vessel's summary final statement. Vessel states that the public sewer closet to 37 Hartford Avenue as it is at the intersection of Route 189 and Route 10 and 202 and is more than 1,700 feet away. Michael says this information is incorrect. The gravity sewer ends at the intersection of Route 189 and Bank Street and is less than 800 feet away, approximately 780 feet from the front of 37 Hartford Avenue. Let's see. Vessel states that in October of 2023, Town Planner Kenyon prepared a memo that explained why sewer is not available and that the town has, quote, no plan, end of quote, to extend the public sewer line. Town Planner Kenyon submitted a revised memo in February clarifying that, quote, as the town does not have plans at this time to extend sewer, if a sewer connection is wanted or needed within the sewer district, it would be up to a developer to propose/design an extension for review and approval from the WPCA. Vessel chose to ignore this clarification and refused to propose/design an extension for review by the WPCA. Granby's Affordable Housing Plan, page 25, number 4, section B states that the town plans to study the extension. And additionally, on page 16, number 10, this extension must be served, this development must be served by public water and sewer. Recently, the sewer flow study came out, and it stated that an extension will go to the East Granby town line of the sewer. Vessel states that in order to connect to the gravity sewer system, the town would need to approve installation of new 6 or 8-inch pipe installed parallel to Rushford Reed force main, which would make no, quote, engineering sense, end of quote. If Vessel were to propose and design a sewer extension, Rushford Mead would have the opportunity to connect to this extension, and the existing force main in the street would be shortened. To simplify, Rushford Mead force main would no longer run parallel to the extension. It would be removed and tied to the system in front of their property. Rushford Mead would still own and operate their private pump station, but would now discharge to a gravity sewer that would be in front of their property rather than at the intersections of Route 189 and Bank Street. Ignorance of this simple design shows a level of incompetence on the part of Vessel Attorney Hollister and their engineering staff. Number 6, Vessel states that an application to the Granby WPCA would have to start with an amendment to the town's sewer plan because it does not contemplate sewer service to 37 Hartford Avenue. In addition, any sewer built by Vessel would eventually be turned over to the town for ownership and maintenance. The town's sewer plan currently depicts 37 Hartford Avenue within the sewer district. We've heard that a couple times tonight. Planner Kenyon has reinforced this in her clarified memo. Transferring ownership of sewer main is common practice, and with the proper engineering and inspection of the installed system would pose no hardship to the town of Granby. Number 7, Vessel states that in many towns, sewer extensions are only granted to properties with known or probable septic failures, and that south of 37 Hartford Avenue, many properties are on septic with no known failures. Mr. Fusick says, the properties utilizing septic in this area are mostly single-family residential homes or small businesses that operate only during normal business hours. Attorney Hollister's comparison of septic systems does not reference the difference in size or the use of such systems. A development of this magnitude with a septic system poses a much greater concern and probability for failure versus a residential home or a small business. My comment is they've been giving you assurances, nothing. They speak in absolute terms, but nothing is a certainty. Science is fallible. These distorted and broad statements made by Vessel highlight a dangerous form of deceit and need to be investigated beyond their claims. Number 8, Vessel states that new sewers generally cost about $900 per lineal foot and that a 1,700-foot extension would cost about $1.5 million. Did Attorney Hollister provide a breakdown of cost or how Vessel computed these grossly exaggerated figures? Assuming the highest cost for installation is at $250 per linear foot, would cover all expenses and extend to a total of $200,000 for an 800-foot extension. Again, we must question the statements provided by Vessel, as they do not seem to be based on anything with substantiated evidence. Could you put up the slide, please? Now this is me, my time. El Nino and La Nina, we've talked about water and rain quite a bit. And this graph shows you, and this goes back to 1950, 1951. The red represents El Nino, which means a lot of rain coming our way. And when you compare the red with the blue, you see that there is another category called very strong. That means there's a high probability that there will be more rain coming. And this has been verified by the Oceanic El Nino Index people. If you look across to the blue, you see there are 12 incidences of La Nina, which is weak, and then 6 for moderate and 7 for strong. They don't have over there a very strong column. But this shows evidence that we're in store for more rain. Dr. Danzer, when I asked him about those additional water and rain increased nitrogen, said yes. It may be naturally occurring, but rain is a pretty natural occurrence when you're in a weather pattern such as this. I have other comments, but it looks like I'll have to save them. Thank you.
Thank you.
Good evening, Tony Flanagan. It's amazing how we're still here doing this, number one. Number two, we're still looking at plans that still aren't finished, that we were told were handed in January, never were, but then handed in April 1st. That in itself shows me lack of professionalism in saying if this is how you handle something as simple as a revised plan to how things will run with the apartment building. That's frightening. Last we heard, Attorney Hollister had spoken with Mr. Ronald Ferris from DOT. I spoke with him on March 19th at approximately 1:30 p.m. And that day, I had asked him about, I know you had a conversation with Mr. Hollister about a sewer system. He said yes. If Granby was going to extend their sewer system all the way to the East Granby line, they should have done it while they were doing the center study, he said, because that would have made it a lot easier for them to just keep right on going. But because they didn't, of course he's going to deny it, but the one thing that Mr. Hollister did not ask was about putting in a forced main feed. I asked Mr. Hollister if it would be possible to put one in, and he absolutely agreed, yes, he would be in tune to put that in. What Mr. Hollister was getting at was a full-blown sewer system, not a forced main feed. I asked him about the forced main feed that he said would be possible. Instead, what bothers me is we only ask questions that we want answers to. We don't ask questions to all avenues to proceed forward. And that's what's happening here. I also read in the responses in the packet, the pumping the septic no less than a 5-year frequency is asking of trouble. Shows how much they don't know about septic systems. Single-family homes pump theirs every 2 to 3 years on an average. They inspect them after being pumped, to which they're on an average 4 to 5 people. Imagine a 42-unit apartment. The frequency of pumping for a 42-unit apartment, to which have no idea how many people will be living in these units, no less than a 5-year frequency, is not suitable and will fail. He also said that we will make sure to avoid any adverse effects to the owners of the building. I'm sorry, I thought Vessel was the owner of the building. Are we selling it? Also, in your wonderful 900-plus page packet, you first state that the wetlands are not protected. In 2008, Jody Rell put it forward. In 2018, Senator Murphy and Blumenthal made it protected. You also put in there copies from a book from which at this year in time is moot. It was published in 1996, and if you have been doing this for 32 years, I think you would have gotten more recent relevation to this. To which most of the data that was recorded here is out of date, and regulations have changed since then. This was useless. All I see is what they do in Congress, put together a huge bill, or in this case, packet, sneak what you can in there and hope when you look at it, they just say, vote yes and be done with it. We went through this packet and we're not stopping. If you're gonna be here and you're gonna say you're gonna be 8-30, I wanna see a deed restriction on them now. Thank you.
I'm Myers on 38th Street. I was getting rigor mortis sitting back there, so I had to come up and talk.
Mr. Meyer, you mentioned that you had a PowerPoint. Did you hand it in?
Your part?
Before the
Yes,
hearing,
I handed the PowerPoint.
Do you want the B one or the C one?
Your part?
The B one or the C one?
Take the PDF, go to the second page on the presentation, okay? I don't need it right now, I just want to make a comment.
Okay.
I intended to come up and speak on a technical matter.
You still have to identify yourself for the record, even though.
I thought I did.
He did. Oh, he did? I'm sorry.
Yeah, I'll do it, yeah.
Sure.
I got enough arrows pointing at me anyway, so what's the difference, right? Reinhard Meyer, 138 days.
Thank you, Mr. Meyer.
My real purpose this afternoon, this evening, I should say, is to discuss a technical issue regarding the recent applicant submittal. But I got to make a comment before that. After tonight's performance, I'm a little upset. It's almost get the impression that, well, we're just a bunch of hicks up here in the country and we don't know about anything. But let me tell you something. I have done hundreds of millions and billions of dollars worth of site assessment, site development, and permitting. I'm that old, yeah, okay? And I'm not impressed about what was going on here. I'm glad you woke up for a change. We do know what we're doing. We have other people here in town who've got advanced degrees and experience that you need to respect also. If you want to come into town, respect the people. Okay. Why don't we just flip on to the next one? I don't want to go over this stuff again. Listen to them. Get down to this one right here. Yeah, okay. Now, what this is an extraction from the H&H Engineering drawings. And it's the sectional cut, okay? Right about the middle of the back lot. What you see on the top is the parking lot, the paved parking lots. And what I tried to do here is overlay the December 8th sectional side with the new one that's, I understand now, in front of the state. And to give you an indication of what is being done here. The December 8th issue had a double actually, but a single row of leach fields out in the back. And apparently what happened was when they decided to move the building back by about 50 feet, they had to bring this to change the system. Now the system are air blown, okay? Now, but for them to function properly, so you get the nitrogen under control, you have to have air blown in there. I mean, this is not an uncommon thing. Major sewage treatment plants actually use oxygen. They have big oxygen separators to do that, to reduce the emission effluents. It's surprising, it took them from December 8th to April 1st to make a revision. And the revision contains basically the same number of leaching fields, but they were doubled up on one side. Now, in order to accomplish this, they had to push out their leach field past the top of the existing cliff. So they're putting up now a wall partway down the cliff, okay? Slope, okay? In my opinion, this is first of all, it's a constructability issue. Second of all, I think it's a recipe for disaster, because if you get effluent coming out of the leaching fields, they could come down, undermine the wall, and when that wall could collapse, you could have a torrent of cars winding up into the wetlands. That's an opinion. It's based upon 50 years worth of engineering, and it's a possibility. I can't say it's a certainty, but it's a possibility. Now, as far as the sewer system is concerned, I have a little problem with the way the town, specifically Mrs. Kenyon, presented it. She's not an engineer, and if you're going to give information to the town and you use an infant engineering basis, at least go to the town engineer, ask him about it, okay? Forced main system is a possibility, not a gravity feed. That goes for Mr. Hollister also, okay? Because that part of the 189 Hartford Avenue is downward sloping. And if you're going to do anything with any houses along there, you would have to go down the hill and pump it back up anyway. So you have a precedent that's already set, 40 years there, Russia and me. There's absolutely no reason why you can avoid this mess and go directly to the sewer. I mean, sometimes I wonder if I offered Mr. Hollister, town offered Mr. Hollister a free ride in a pump storage system, if he'd accept it or not. All right? Here's a chance, Bob. So there is the question, why don't they go that way? I don't agree with the town's position that you can't do it. There's no technical reason why you can't. Thank you.
Mr. Flanagan?
Everybody looks tired, including me. All right, this is just my opinion.
You have to identify, even though I said your name, you have to identify.
Flanagan, no, Cliff Drive, I'm sorry. I don't want to rehash some of this, but, when they first came up here originally, they said they were 200 feet from the wetlands. I went down there, I'm going to cut this short.
Recording in progress.
And, is I going to speak, or?
I think you're okay.
Am I okay?
Yeah, you're good. Go ahead.
Right, I went down there physically, and the farm road, which they talked about earlier, is 60 feet from the top of the hill. That's the north side of the farm road. That is wetland. That is where the wetland starts, period. Now, the wetland, it's going to flow, it's going to go to that Salmon Brook eventually, and we all know that this is federally protected wetland. It's not just wetland. They keep leaving that out. Okay, another thing on this revised plan, which Reinhardt just talked about, the retaining wall, whatever it is 10 feet pushed back towards the wetland. This is crazy. Why are you going back towards the wetland? I mean, it's foolish. And, they keep bringing up vessel 2007 approvals. This is a different animal. There are four offices on 30 that were supposed to be built on 37 Hartford Road. This isn't 42 units. It's totally different. And it's ludicrous to even make that comparison, but it's in the new packet, 937 pages. Are you kidding me? That inundates you people. You're like, it's just too much. And now, with what came out tonight, I'm making a formal request that the WPCA board be notified of the impact that is possible here to be looked at with the town ordinances that we have. Some of them may be violated. I'm making a request of that. Also, I'm making a request that before the board does anything, they know what a bond amount is. It was answered before, oh, we don't do that until the board approves it, then we do it. No, that's backwards. What they're proposing on 37 Hartford Avenue, that's foolish. You can't do that. You know, that they should hook up to a sewer. But like I said before, this is too much of an impact for that 37 Hartford Ave. Also, Vessel before has claimed it's highly unlikely that there's going to be a nitrogen impact. That's not a yes or no. There will be a nitrogen impact. And when this occurs, it's a health issue because it's contamination. Okay? That's what nitrogen does. And that's all I got to say. Thank you.
Thank you. Anyone else? Sir, Mr. Johnson?
I'll keep it well within the 5 minutes.
So far, we're doing okay.
Just Kurt Johnson, West Granby. How I came up with $175 per square foot. I've been in the construction bond industry, working with contractors, site contractors, many types of different contractors, and I have access to contractors that come up with very viable costs. And being around the bond industry, having to bond construction projects, I see their estimates. So that's how I came up with 175, and actually I inflated that a bit because just to be conservative. My concern is there's credibility issues here, and I'm going to start with number one. And Abby, you were kind enough to answer my question because I was really unclear as to why Connecticut DOT would decline a sewer extension. And I was not grasping that. Maybe Mr. Levy, you can help answer that. I mean, if I'm asking questions, I'd be happy to have you come up and maybe answer. I have 3 questions. Would you like to answer?
Well, you have 3 questions for Mr. Levy?
Well, they're just general questions. I mean,
why don't you pose the 3 questions if he can answer them, if he chooses to answer them?
Abby, going back months, she was very clear about where the extension would start from at the corner of Bank Street and Hartford Avenue. I just went down myself to the town hall and looked up the plans, and I was able to find the plans. So somebody on your professional development team dropped the ball, or you didn't want to disclose the fact that no one's looked into it, but it was very easy to do. So we know where the sewer line is. So I guess my question is twofold. How I think somebody made the comment on your team that Connecticut DOT was saying no to an extension in Hartford Avenue. Is that correct?
If you want, it's up to you whether you want.
You don't have to answer if you don't want. You're here. I just figured we'd come up and have the dialogue.
Or
That's correct. Our site contractor reached out to the Department of Transportation, told him where the site was, told him that he likes find out about making a connection. He responded that that would not be possible and gave an explanation, and that explanation was provided in our write-up as well as in his response to Mrs. Kennedy.
And I think we've heard that DOT is willing to consider. A lot of sewer and water lines go in the street, trenches on state roads, local roads. Anyway, the other thing is I was baffled where $900 a square foot was derived from. Again, I'm going to look to your professional development team. You guys are in this business. So there's a credibility chink on the first one with the state DOT. There's a real credibility chink on the $900 a linear foot for installing sewer. Where did that number come from?
That number also came from our site contractor and includes all of the costs associated with an extension, not just the cost of the
Trench.
Requires you to shut down the road, it requires you to have.
Why would you have to shut down the road? You don't shut down state roads.
I think he's answered it. Next question.
Yep.
I'm sorry, it's getting late.
Yep, credibility. Number 3, the last one is Has Vessel ever, as a developer, contributed to the cost of installing utilities? As an investment?
Many towns have impact fees associated with their utility hookups, and so.
No. Have you ever borne the cost of extending a sewer line to get to a development and pay that cost? Because many developers do that.
We've not been asked to.
You haven't been asked. Okay. Thank you.
Thank you, Mr. Johnson. Anyone else?
John Marone on 15 Maple Hill. Vessel, they mentioned about beautiful or people coming into the units. You know, they're ranked, there's articles that they're one of the worst property landowners, landlords in America. Also, have they done, I'd like to find out, have you done a lot of these projects with wetlands? How many have you done? Wetland builds? Where, you're not building in the wetlands? Where are you building? Next to the wetlands? Have they done similar projects, yes or no?
I don't.
With septics, that's why I was like, no, or they don't.
I think that was brought up the last time. I think the answer was this is the first septic system. That was the answer we got last.
The first time they're doing this?
Yeah.
Okay. And how many projects, I'd like to know the extent of the number of projects. I think they have one in Simsbury and.
I think we have to focus on this project. I appreciate.
Well, it is a focus because if this is a unique one, it proves based on, you know, the dialogue and the constant switching of voice and switching of things to the control of the honesty. If they've done 20 of these, we could maybe do a research and see, okay, they've all worked out well, or they're going along well.
I don't want to cut you off, Mr. Morone, but I understand your point, and I respect it, but we've got to look at this particular application, and they've already conceded that this is unique to the extent
Okay.
that they have not had to do a
Well,
septic
then I will
system.
follow up with several of the other people in town that's saying, this group is not the most honest group. I don't know where they're all paid, they're all under the same ownership. They're going to say, it's snowing out today. They're going to say anything they want to say to get this done. We have experts, I'm not one of them, but in the town, they're just as qualified, if not more qualified. The threat or the subliminal threat of a lawsuit, and they know the judge and their buddy or whatever they're doing.
Sir, I have never heard them say they're going to.
No, I don't, they haven't said that, but if you read it, if you read into this, it's sort of like, well, you'll have to do this. This is what you have to do. Those are subliminal messages. You have to do it. You have to put your pens down. You have to. So I'm just saying that's not the best way to do that. And you're right. You know, I think the gentleman there said, come in, be honest, and you get an honest assessment.
Thank you, Ms. Morone. Thank you. Anyone else? Okay. Any of these questions raise anything for the commission, staff, the applicant? Anything else? All right, we did not take up the verified petition. So he's asking to be designated as an intervener in this action. That's what this petition is.
Yeah, I mean, and basically, under the statute 22A19, part of the Connecticut Environmental Protection Act, under certain circumstances, members of the public can become parties to the proceeding. You know, he may have standing as an abutter, but as an environmental intervener, he gets certain additional rights if the commission finds that the substance of the petition proves, you know, that he's entitled to that status. And, you know, their item number 2 just basically verbatim takes from the statute the finding that you would have to make in order to grant them environmental intervenor status, which is that they have proven through their testimony and through this affidavit that what the applicant proposes to do is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources of the state. And then it identifies the ways in which they are asserting that the applicant's activities would have that consequence.
So to accept this, I mean, I'm confused. It means that we have already decided that that is all true?
I mean, at least you made the threshold determination that it is reasonably likely that these adverse impacts would occur because of the things that have been stated.
Yeah, so, I mean, let's try it this way, because typically I see these, you're in a DEP proceeding, where, one of the administrative hearing officers is familiar with the process. This commission clearly is not, or you see it in a court action. So if you want to explain your reasons, and then I'll give Mr. Hollister an opportunity to object if he chooses to.
George Schober, representing Peter Boskowski. And we've laid it out in here, but basically, and a lot of it was the testimony that we put on, we believe that the application as presented will significantly adversely impact both my client's property and then, of course, the health of the wetlands and the natural resources of the state of Connecticut if this is allowed. So we're asking to be made a party to this. It does give us some additional rights, namely the right to directly cross-examine the applicant if we so choose. We're not subject to any time limits as far as testimony, but don't vote no because of that, because I'm pretty much done anyway. But
that was my next question.
Yeah, but that's the reason for doing this. It's done as a matter of course in any wetlands. Any wetlands action that I'm involved with in representing a client, and I think a lot of land use lawyers use these. I'm sure Attorney Roberts has seen these numerous times. I'm sure Attorney Hollister has gone through this and compared it to the numerous ones that he's seen over the course of his many years. But we believe that this will harm the environment in the state of Connecticut, and so we want to become a party to this. And it is often used to get someone who is not in a butter in a court action to get them in as a party. But we're using it a little bit differently here.
Thank you.
So,
Mr. Hollister, you want to be heard?
So Hollister, for the record, just two things. The filing an environmental intervention petition gives you the right to present evidence. The petition itself is not proof, it's just a claim. Mr. Schober here, I would point out, Mr. Voskowski showed a video, which I think we all saw as kind of inconclusive, or at least subject to debate, depending on which way you look at it. But then otherwise, Attorney Schober relied on Dr. Danzer, not anybody else. And Dr. Danzer's not here, and Dr. Danzer was certainly not commenting specifically on Mr. Voskowski's property. So I think they opened the door to present evidence, but then they did not present evidence that would allow you to make a finding of an unreasonable impact on natural resources. So for that reason, we object.
Don't we just need to have a verified claim that there's a significant impact?
No. The verified claim allows you to come to a hearing and present evidence.
Right.
But that now we're ready to close the hearing. They've made their presentation. Now you have to evaluate their presentation.
Right.
And so my points are, the video was equivocal, inconclusive, and Attorney Schober only spoke of what we already have from Dr. Danzer, nothing specific to the property of the Mr. Voskowski.
Okay, I understand your point now. Mr. Schober. I feel like I'm at short calendar on Monday at Harvey Superior Court.
Very quickly, Dr. Janzer was commenting specifically on this property. My client's property is where the wetlands are. That's where he was. That's what he evaluated.
Thank you. Thank you.
I don't quite I still don't quite understand. The process here that we are requested to accept this,
It's like we're saying.
You received this, and Attorney Hollister explained it correctly, that just basically sets up the opportunity for the environmental intervener to say, here is our evidence of that what the applicant is proposing to do is reasonably likely to have the unreasonable.
So, but we are not, by accepting it, going ahead and agreeing with that statement.
If you grant them environmental intervener status, you are agreeing with that statement.
Okay, because to me, that's the heart of the issue here. And if we have decided on that, then we've already decided on the whole issue here. So I don't understand.
No, you're right. I mean, it's essentially, kind of a threshold determination of the ultimate issue.
Okay.
By,
I mean, but the bottom line is he's in a butter. He's got statutory standing anyway. So.
Right. And if you say that was a great video, but it doesn't satisfy us of, unreasonable impairment of the public trust, you can appeal that.
This is, are we doing this in proper order, though? Shouldn't we accept whether or not this goes through, and then they would come back and provide evidence?
No.
They provide evidence at the time.
They have to provide evidence to basically support this before you can accept it.
Okay.
This is kind of like an application to become an environmental intervener. And it states some things and they put on their case.
I still don't see how this is different from our going ahead and deciding on the application.
Exactly.
If we were to agree to this, it sounds to me like that at that point we have decided on the application.
Yeah.
By agreeing, doesn't it just mean that down the road, he is now able to come in and
That's what I'm
testify?
trying to find out, but that's not what you said.
Well,
because we allow him this privilege, it doesn't mean that we accept all the assumptions. I don't get that.
You have to agree with their assertion in order to accept this.
Okay.
Well, we have the evidence. I think you stated, Mr. Schober, on the record that you don't intend to have any more, to present any more evidence or cross-examine the applicant. So it's really belt and suspenders to a degree. I think the commission is concerned that it implies to the applicant and to the public that we somehow agree with these assessments when we haven't even had a discussion about it.
Right.
So, I'll take a motion if someone wants to, but it does. I'm sorry.
No, go ahead.
It seems like at this point, you have your evidence in the record. I think you're well protected. Or your position is well protected. All right. Anybody else have anything else?
Well, I think you want to act on this.
Yeah.
Do you want to act on this?
I would recommend you act.
Then somebody's got to make.
Either accept it or deny it.
We have to receive it first.
You've received it.
We've received it, okay.
Yeah.
I move that we deny it.
Is that a motion? Motion
Yes.
to deny the petition to be an intervener? Is there a second? We're never going to be able to discuss unless someone seconds it. And if it fails without a second, is there another motion?
I move to accept it.
Okay. We have a motion to accept the petition to intervene. Second by Nick. Any further discussion?
Well,
Vicky.
Vicky, did you say something?
I was just voting yes.
Well, we haven't gone to the vote yet.
Okay,
where you're coming from.
But if we vote yes on this,
That
we're
means-
all done.
No,
No.
not at all.
No, that just means the process continues and that they are able to participate as a party, meaning,
But
You
you
know-
just said a minute ago that it meant that we agreed with this statement.
correct.
So,
But that
if
is
I
the
may,
issue.
yeah, if I may, for a
But
little
that
clarification.
just allows it to continue
Okay.
with them as a party. I mean, if they have additional evidence that proves you made a wrong decision in making them an environmental intervener, then that doesn't bind you to the ultimate conclusion.
Yeah, so
That
you,
was my question.
yeah, so you would, the commission would be able to vote however they want to vote, come time, regardless of, acceptance or denial of the intervenor.
I'm
Okay,
sorry,
because
Rod,
that
I didn't
wasn't-
understand the question.
That wasn't
Are
explained.
you satisfied with that answer?
Yes.
Okay. Any more discussion on
Thank
the
you.
motion
Yeah.
to grant the petition to intervene? All in favor?
Needs a second.
I thought we had a second.
She didn't have a second, it was
Sorry,
me.
Nick.
That's right.
It's getting late.
We're not even.
All in
third
favor?
way through.
Opposed? You're opposed? We're going to take that as a yes. You approve. Abstentions? John Ladati? All right, thanks.
Okay,
All right, now, what's next? Public hearing is still open.
close the public hearing.
Is that a motion?
I make a motion to close the.
Oh, I'm sorry, man.
I make a motion to close, to close the public hearing.
I just, point of discussion, does that deny the new, what we just approved, does that deny them the opportunity to come back and submit evidence?
Deny.
Or are they done submitting evidence?
They're done.
They're done.
Okay,
I mean,
just wanna make sure
everybody's
that they
done.
didn't want, if they have the opportunity to come back.
We're done as long as the public hearing is closed. If the
Right.
public hearing remains open, then just like anybody else, we would want to be able
Of
to.
course, okay, very, yeah,
But
thank
Make
you.
a motion to close the public hearing.
Second.
Okay. Further discussion on the motion to close the public hearing? Hearing no further discussion, all in favor?
Aye.
Opposed? There must be a delay. I'm taking that as an aye, right?
You get the 7-second radio delay.
Hey, we're spending $4 million on a communication upgrade. Put the Roman here on it too.
Abstention? Did you hear that, Vicky? All right, the public hearing's closed.
Yay.
Thank you all for coming. If anyone's still awake, we have more on the agenda.
We have 45 days to act on
might you be
this.
voting on this tonight or no?
Yeah, you guys.
No, I don't.
Whether we can leave.
You can leave. I don't anticipate voting on this tonight.
Thank you.
No.
Thank you very much.
We've got a lot,
Statement
yeah.
on that, so-
In fact, I'll give
Yeah.
you the assurance, we're not voting on it.
Make a statement though, because we have what, 30 days to act or 45 days? 35.
They know.
You have
She
65
wants a
days
statement.
to,
You make a
Oh.
statement.
35 days?
35 days?
65.
65.
We have 65 days to make a decision. All right, let's go to agenda item number 4, permit request, 233 West Granby Road, Katie and Valentine, permit application to construct.
If you wait, the audio, he's not gonna be able to get any of it.
Okay. I'm going to ask everyone who's not going to be involved with this agenda item to either be quiet or leave. Or both.
You're done now.
All right, let's try it again.
Okay.
I'm going to start from the beginning. Agenda item 4A, 233 West Granby Road, Katie and Valentine, permit application to construct a 24 by 24 foot carport, an 18 foot by 36 foot above ground swimming pool, 12 foot by 10 foot gazebo, a rear deck within a regulated area. We had a public hearing on March 13th, 2024. Is anyone here from the applicant?
Yes. Good evening, everyone. Katie and Valentine.
Good evening.
Address-
Thank you for your patience.
Okay. Address 233 West Granby Road.
Yes.
So,
Are you the owner?
yes.
Nice to meet you. Thank you.
So, yeah, I'm not sure how how you wanted to run this, John, but,
I know you've been to the site.
Yeah.
Okay. So I'm assuming you've met with the applicant.
Yes.
Okay, so who wants to tell me about what's going on? This started out as a notice of violation.
Correct.
We withdrew that because they filed a permit application to do the things they want to do. Do I have that right procedurally?
We did not withdraw it.
It's still, okay.
Yes. Yeah.
All right, but this, if granted, if it meets the regulations, would resolve the notice of violation. That's how we're trying to accomplish.
Yes, I believe so.
Okay, thank you. All right, so who wants to go first?
I'll let
Katie-
Cameron go first.
Okay, sure. Yeah, we met with Cadian a few times out on the property. The most recent being, trying to see the date on here, Wednesday, the 3rd of April. So that was myself, Cadian, Omar, who's also, I believe, living there, and Abby Kenyon. So we met on the property to discuss things going forward, discuss the work that's been done. Silt fence has been installed, and there is a dumpster on site to clean up the trash, as noted in the violation, or the notice of violation. So, they are being compliant with the notice of violation, which is much appreciated. In discussions, and this is all, I'm kind of summarizing my email, which has been provided to everybody, I believe. In discussions with Omar and Cadian that day, I revised my planting plan, which should also be passed down, sort of a brief description of the planting plan. I was not able to print out a map tonight to show the general locations there, but essentially we moved the planting plan specifically down to the back right corner, the southwest corner of the property, or of the yard, I should say, where additional grading is possibly being proposed. And it's still my recommendation that a planting plan be required by the commission, just due to the unstable nature of the soil in that area and the proximity to the stream. So that said, there is some additional sediment buildup past where the silt fence is located, and that should be removed and spread in an appropriate location, and that was discussed with Omar the day of that site visit, and I did mention that could be done anytime and does not need to wait for the wetland permit itself, since it's not sediment that's in the stream, it's not dredging or anything like that. And Omar did mention that grading is not complete on the site, and so I did request that the final grade be presented to the commission for review, and as best of a grading plan that could be received, would be beneficial, and that we know sort of the timeline on the grading itself. And then I checked with the chair and vice chair of the Wetland Commission to see if there were any additional questions. I don't believe I received any. And finally, I just asked that the silt fence not be removed from the property until a permit is received, and then, in the permit, it would outline when that silt fence could be removed. Other than that, there was sort of general discussion about possible additions to the permit. I believe that we determined that was not going to be part of this application, and that may be something down the line. But so I just wanted to throw that out there. If anyone has questions on that, I can go into it a little more. But
I'm a little confused because the application is for the things I cited, the gazebo, the pool.
Yes.
Deck. You're talking about additional things in addition to that?
Yeah,
I don't
so
know,
I just wanted to throw that out there that that was discussed, but there was no timeline, no hard plans on that, and so I just felt it prudent to mention. But it's not going to be part of this application.
Okay.
It may be part of an application well into the future, but no hard plans or any timelines associated with that. I believe that's it. And then one other thing, just in the interest of disclosure, I did meet with the neighbors over on 6 Day Street South at their request to discuss the ongoing violation. And I would just like to clarify that meeting and its contents will not be included in this permit application, as that's a separate issue. The notice of violation is separate from the permit application. And as the public hearing has closed, I don't want to provide any additional information that is not necessarily factual. No. So.
But that meeting was in connection with the notice of violation.
Yes.
And it sounds like everything you just told us, the sill fence, the grading, all that stuff was in response to the notice of violation.
Correct.
Yes, but any additional grading would need to be submitted in the permit application. Was more so my point.
Okay.
And then the recommendation that a planting plan be a condition of the permit as well.
That wouldn't be
right.
Notice of violation.
Right.
Okay.
And I believe that's all that I have.
So where did we leave it with the permit application? We closed the public hearing.
Yep.
Okay. So I don't have. Do you have the packet that was given at the last hearing?
Well, we have this today, but no, I don't have the last packet. I don't have
See, Abby's running to get it.
Yeah, I don't have that.
I'm sorry. This
okay.
public hearing was just so absorbing. We're a little disjointed.
So question, Cameron.
Yes.
You stated that my neighbors on Dayhill, they have query in regards to this violation, or did I not hear correctly?
Yes, so it's regarding the violation, and so that's not regarding the permit that's being discussed here tonight. So the best way to describe it, I think, would be that the violation, the notice has already been issued, and the town does not at this time plan to pursue any further action on that. But regardless, the neighbors asked that I meet with them, and so I did, and we sort of discussed things where they're at, as they were unable to attend the public hearing. And so that's a separate issue and not being discussed tonight.
Okay.
Yeah.
But this hearing has been recorded, right? So it's easy to, okay.
Right.
This is what we saw last time. It shows the carport, the deck, the silt fence. Yeah.
Wasn't there a drainage?
Yeah, there's a pipe connected to the curtain drain right there.
Right.
It's connected to the curtain? Right?
Yeah.
Okay, because it looked like last time, just kind of spilling out on the.
Right, yeah, and that was something that
We
the
discussed it,
commission,
right.
Yeah,
had
I thought,
requested
yeah,
at the last meeting was details
Right.
on, how that's going to outlet
Because they had
and
to fix
exactly
it
where.
and do something with it. Right.
There will be a pipe connected to the curtain drain without falling in the northwest corner, okay? Excellent, okay, so we closed the public hearing, so we just need to deal with the application itself and the applicant. So where are we on the permit application?
So, I guess, if Kadian has anything else to add, the commission would take that into account, and then the information that I presented, you can ask questions of me or of the applicant, and, if you so choose to issue a permit, conditions can be applied,
So they want a blanket permit for all of this work to be done. I remember that you said that last time. It was just, she wanted everything on one permit type.
Yeah, the carport, the deck, The 18 by 36
Gazebo.
above-ground pool
And
and
the
the 12 by 10 gazebo.
Right,
That's what's on this plan.
Right. 5 years to complete the work.
yes.
Under that.
Yeah. But,
What are the staff comments on the permit application?
Other than what was presented at the last meeting and today, the only other comments that I have are that, the applicant has submitted a plan. I believe, the commission has asked for additional information and revisions regarding that curtain drain. I don't believe that has been received to date. I don't believe we've received anything about the grading, which I think should be included in the permit application. And then the planting plan has not been agreed upon by the applicant. And, that would be something that if it's included as a condition of the permit, I think that, discussion should be had about whether that planting plan is appropriate in the eyes of the applicant and, the feasibility of that. So I think the commission should discuss sort of those parameters with the applicant here tonight. And if need be, continue the application to receive more information.
I was going to say, can we ask for these 3 things to be done before we vote on the application?
You mean done, you mean
Put together as a plan. Right,
yeah, not be
exactly.
done. We're not gonna
Right,
do a planning.
right. Put together as
In
a
April.
plan, the curtain drain, the grading, and the planting plan before we make a decision as a group.
So if I may,
Sure, of course.
we do have a diagram. We came here a little bit early, but Cameron, you weren't here, so I have it. So I'll give the one copy, you can keep it. So we did have a plan or a somewhat drawing with the curtain drain pertaining to what Cameron had suggested, which was the plan. I stated to Cameron, 2 things. 1, what type of plants, and 2, the cost of the plant. Where the stream is, the stream or the lake stream, where the stream is located, we had previously plants that's growing back. I think it was you, Amy, who indicated that to the right of the property, if you're standing in the back to the right side of the property, she indicated that down that slope that's where you'd indicated that we needed the plant or more plants. But there's already plants that's popping up back where they were.
Do you know what kind of plants?
I'm not good with, no, I don't.
Okay.
Yeah, so just to clarify a little bit, so when we had the site visit, we were looking at the back corner where there was some significant grading there and it was built up quite a bit. And that was in the location where the silt fence has been installed. But if that is the final grade, and I think that's what it goes back to, what is the final grade? We had suggested some additional plants in that area to help hold the bank a little bit.
I was going to say help erosion.
And I know, I believe there were daffodils that were coming up, which that's not good for stabilization. So that's what we had talked about. And that's why we encourage you to talk to the commission about that. So that's to clarify the slope and the topography and the whole planting plan point of the application.
Oh, and so I had some printer issues earlier trying to print out photos. But so there were a few photos included for some people with my email and the planting plan. So I kind of tried giving them to every other so that people can look on with the people sitting next to them. So the grade in the back right corner that Kadian was referencing, so if looking from the road on West Granby Road at the property, the back right corner, which is the southwest. So that corner, the grade in its current form sort of drops off. And so kind of to Abby's point, we were suggesting a planting plan for that corner because of the grade and the proximity to the stream, and trying to, just hold that soil together for the future and not have that erode into the stream, was sort of the thought behind that. And while there is.
Excuse me, that's in the regulated area?
Yes.
Okay.
Well, in the upland review area, yeah.
Upland
yeah.
review, okay.
Yeah.
That's, I just want.
So, yeah, for clarification there, essentially the entire property is in the upland review area since it's 200 feet from the stream.
Yep.
I'm not sure if it's exactly the entire property, but most of, if not all of the property, I would probably say the entire backyard is part of the upland review area. I think that's fair to say. So, yeah, and I would say it's essentially 10, 15 feet is that corner from the stream itself. Again, that's just an estimate, but that's essentially how close it is. And there is existing vegetation and leaf litter there. And then there is, to Cadian's point, some vegetation coming up. I just don't believe that it's substantial enough vegetation to hold the soil together and to prevent erosion from entering the stream.
And the suggested planting plan that you came up with?
It was just.
Yeah, so a very brief little planting plan there was to plant 1 to 3 shrub species for a total of 5 shrubs, post grading, planting it about 4 feet apart, and taking care not to plant them too deep so that they're successful, and choosing those species from streamside buffer plantings document, which again I meant to include but had some printer issues. And then on top of that, kind of if it were a condition, having this as sort of a possibility is to have some sort of erosion control seed mix spread as needed. So if, bless you, if the commission finds that, or staff finds that the shrubs that were planted are unsuccessful, that seed be spread in addition to that instead, in that area.
Yeah, yeah.
Yeah.
Absolutely.
Yeah. And then obviously, I'm not sure if it's something that you'd want to go as far as to make a condition on, but seeding the yard post grading, just with grass, regular lawn seed.
I mean, 'cause the yard is essentially just completely stripped.
Yeah.
Right.
So were you
Right.
planning on growing grass in the backyard, Ms. Valentine?
I was.
Okay. So that makes sense, once we have the final grade.
Yeah. I definitely think we need
It's not final, the grade is not final now?
No.
No.
Yeah, Katie,
Yeah.
can you just clarify that? Are you guys
I
going to be?
believe it is. I'm not sure what you and Omar spoke with, but the last
Okay.
time I spoke with him, because when you guys came out, I left shortly after.
Mhm.
So to my knowledge, and when you mentioned about the additional stuff on the plan, that's not to my knowledge. I'm the owner, and there's no additional stuff because there's already costs building and completing it. So there's no additional cost in doing anything apart from what's written on the permit. Pertaining to your question about the grading, to my knowledge, I don't see why we'll need to go lower or go higher. I believe
Okay.
it's final. So I don't know the conversation of you and Omar, what you guys had, but
Right, gotcha.
to my
So
knowledge,
just to clarify that then, so you're saying sort of that you don't think that you're going to grade anymore? Or,
No.
is there
That's to my
any
knowledge.
plan to, seed it as is? That's the plan, is to
That would be the next
make
step.
it into law and how it is, yeah.
that would be the next step.
Okay,
Yes.
okay, thank you.
So
Yes.
that's,
And also with the message you was just reading, is it possible you could forward that email to me? Because I don't remember seeing that email. that you-
Yes, yeah, that was sent to you on the 3rd.
If you could just forward it back to me, that would be
Yep,
fine.
absolutely, yeah.
yeah, big time. And I think, is,
So are you proposing, were you concerned about this area that's where the silt fence is?
Yes. Yep.
Okay.
So you can see there's sediment on both sides of the silt
Yeah.
fence that's
Yeah.
looking out towards the yard.
Was that sediment there before the silt fence went in, or did it
Yes.
leak through?
No, it was there before.
Okay.
Yeah.
You see the picture I'm looking at? Ms. Pell?
Yeah, I was there with Cameron and Amy.
So, yeah, I guess the concern for the commission would be to get this just a little flatter and get some nice, the types of shrubs that'll just hold that hill so we
Yeah,
don't
it has to
continue.
be stabilized.
Yeah, that's got to be stabilized.
Correct.
Because otherwise all that dirt's gonna go into the stream and block the stream.
Correct.
Right.
That's what Cameron had suggested, that we spread
Right.
it out.
Yeah.
We spread it out.
So I think if, we'd be prepared to act if we understood the grading plan, the planting plan, and Fred's got a lot of questions about the curtain drain.
Yeah, I think we talked about this the last time, but if you look at the plan, or at least this picture, it shows that you've got a French curtain drain around the house. And then the drainage from that goes out on a pipe that's spread out across the front lawn or to the northeast, northwest.
To the front, that's
Yeah.
correct. But to my understanding, I
And
think
then, is that just dumping out on the ground?
I'm not sure, and I would not like to say yes or no, and then it's not. But to my understanding and watching the last clip that Amy or you sent me, I believe Omar had made it clear that they were, instead of putting it to the front, he was going to put it to, if you're standing at the front, the front door, then it's going to be to the left. The simple fact that the neighbors above us, their water comes down and it's a slope, so it's literally like passing and sit like right out our driveway. So he was suggesting not to do the same thing and actually put it to the left, if I saw the video correctly.
Isn't there a culvert or something on the main road?
I'm sorry, what was the question?
On West Granby Road, the main road, 20.
Yeah.
Isn't there a culvert that the water could go into?
Is there?
Culvert is.
I don't know.
I don't know. I don't know.
Sorry, what was the question?
Was there a
Is there
culvert
a
in the main
culvert, on
road?
So,
Route 20?
sure.
Yeah, if you want to answer.
Yeah, so 20 is a state route, so one, I don't know what the procedures are to tie into a culvert on a state route. I believe there's one on Day Street South, because there are some drainage issues in that area that I've been in touch with the Director of Public Works about. But the proposal or the plan that was submitted shows the curtain drain extending out when you face the house from the right-hand corner. Just like an open outlet as
Right.
far as we were aware. And I think that's why the commission had requested additional information
Right.
regarding that.
And what I'm my first question was, is there something on Route 20, a culvert that it can go into? I know that, I used to live on Day Street South, so I know that area very well, where there is a culvert that goes underneath the street, carries that brook that goes through there. So we can hook into that, perhaps.
Yeah, and I don't know off the top of my head. I think that's something that the applicant would have to look into and post something if that's what they
But it's better to let you just dump out on the lawn
And all those bricks.
and create an erosion.
Can we move to just have, these things need to be addressed for next month? I mean, this is too much going on. Like, let's get these addressed, and then we can move on to approving the application, because
Yeah, so there's the curtain drain issue, what the planning plan is, and what that grading in that corner is.
Right.
So if we can just tighten that up, we'll look at it at the next hearing.
Yeah.
So, but the draft that was presented, that's not sufficient. You guys need
No, we need.
additional?
We need to know what the planting, it's very common for where you disturb in the regulated area, where you disturb the area, we very often require planting just to stabilize it.
Yes, I get that.
So we have to identify the plants,
The types of plants.
the 5 shrubs that Cameron's, and then
Right.
that curtain drain, we just got to know where it's dumping out into and what it's dumping out into. If it's going to disperse, there should be some plan
drainage
that
plan.
shows how it's dispersing, how it's not increasing runoff.
Okay, I understand.
You don't want to create what your neighbors have created for you.
Okay.
You know, and then the grading in that corner, it's got to be part of the grading plan and the planning plan. It has to be integrated, I think. I'm not the scientist who's sitting over there. It's got to be integrated into one plan. So, whether that slope gets flattened out a little bit and the shrubs are there and you all agree that that's going to stabilize it, that would be good for that corner.
Okay.
So I would suggest if Cameron has the time to do another site meeting, tighten that up and come back to the commission so we can vote on the application.
Okay.
Could these even be addressed before next month? Like, if you could finalize the grading and get a couple plantings, then could we just move forward at that point?
Yeah, so if that's agreed upon by the commission and the applicant, that's a possibility.
Who's
It
doing
sounds
the
like
grading?
I'm sorry?
Who's doing the grading?
I'm not sure as yet. We have a few persons that we always use, so to say this person and then perhaps that person is not available, that we'll do. But pertaining to the planting plan, you're suggesting perhaps in the month?
I'm saying, like, if we be another month and you get those plants in, we're defeating the whole purpose of taking care of the problem. So, but it sounds like you have to do the grading before you do the planting.
And this is why I'm kind of.
So yeah, I was going to say, if I may, it sounds like, and please let me know if I'm speaking incorrectly for you, but it sounds like the applicant does not want to plant the plants unless it's a condition of the permit, because she doesn't want to pay the expense unless she's required to do so.
You want to put plants in there, so you should have plants in there already, because you're going to lose all that.
But it has to be graded there.
Right,
But it has to be graded, so you got to grade it, you got to plant it.
Correct, so it's steps. So it's steps. So
Months ago. We should have
Not-
done it at all.
no, not
But now we're
necessarily.
mitigating,
It's
so now you got to take care of it.
if the weather was good, yes.
I know, but you made the mess, now you got to clean it up.
And that's what I'm trying to do.
Speaking
Trust
personally,
me,
I would just,
am.
I'd feel better
Because I
if we
wouldn't
had
wanna
a
be
clear
here.
plan that we could approve rather than make it an agent review. Because I'm kind of in the dark about what's going to happen in that corner there.
Yeah,
And, and how that.
I don't want to put the burden on you to make this decision, so I think it should be shared by all of us. And we should keep an eye on it.
Okay, we haven't approved anything.
Okay, yeah, but,
We have the permit
Right.
application, so there's like 3 open pieces on it, I think.
right.
So, Katie, and I'll send an email tomorrow as sort of a follow-up to this about, what was discussed tonight and what the commission would like to see at the next hearing. And, of course, anything you need help with, any questions you have, just let me know. And I can try to make myself available. And yeah, just if the commission has anything else to add now or later, send me an email individually, and I can add it. Go
Maybe
ahead.
we can help her too by giving her examples of previous planting plans that have been done and grading things that have been done. That would help her understand what's expected.
Right.
Yeah.
Okay.
Would you should come back to say, I'm going to do, this is the grading plan? Or
Yes.
can she has to come back and say,
Yes.
the grading plan?
Yes.
All right, I know, I'm just trying to fix it before.
It would be a condition of the approval once we have it.
Right.
tightened up.
Right. I just hate to see it go, it's going to get hit again next week, and it's going to.
Well, at least this silt fence is
Yeah,
in
the silt
place.
fence is in
Yeah.
place
Just gotta
and
get to that.
functional, yeah.
Right.
But, the sediment that's behind the silt fence should still be removed and spread in an appropriate location, such as the other side of the silt fence in the yard or other suitable location. And again, as I said in that email, that can be done without a permit. That's something just, preventing additional impact and, just kind of property maintenance. So, yeah.
So is there, that curtain drain is just taking water away from the French drain, the around
To my
the foundation?
understanding.
Are you getting integration into the basement now?
Water?
Are you getting water into the basement?
Not now, but prior, yes, when we had the excessive rain, I forgot what month that was, we did have water. Yeah.
Do you have a
But
sump
not-
pump?
I'm sorry?
Do you have a sump pump in the basement?
In the basement, yes, we do. We do. We bought it like that, yes.
So it's basically a problem that presents itself when there's a lot of rain.
Correct.
Okay.
I would assume. I would assume.
That's very common on Day Street side. I
was
know.
told, yes.
All right, I don't have anything else. Anybody else? All right, so you guys stay in contact and hopefully we'll have it tightened up and we can vote on this next meeting.
Okay.
Thank you so much. Thanks for your patience tonight.
Thank you.
I'm sure you found that last presentation exciting and interesting. All right, next on the agenda. Where's
Stay
my-
awake, Kevin.
You have to go sit out.
Do you want me to sit out in the
Yes.
audience? I can do whatever you want. Yes?
Yes.
Yes.
It's traditional. I had to do it.
You did?
Yeah.
Commission hazing.
Yeah. I'm happy to with that.
Yeah, and commission hazing.
Oh, it went that way.
I don't have the copy.
Yeah, it's here somewhere.
Is this,
It's right behind, right there. It's right there.
you want this one?
Yeah, do you have the narrative so you put back in the file?
Narrative is
This one?
this one?
That one.
Yeah.
No.
No, this one.
Yeah.
Want the photos?
Okay.
Okay.
Yeah, I mean, I think those are all photos you would send.
All right, next agenda item.
I recuse myself.
Well, let me announce it before you recuse yourself. Okay. Permit request 4B, 147 Loomis Street, an S. Okie. Permit application to demolish an existing 36-foot by 24-foot agricultural barn and rebuild a new 40-foot by 36-foot agricultural barn within a regulated area. Okay, anyone here on behalf of the applicant?
I am here on behalf of the applicant. My name is John Greer. I live at 147 Loomis Street.
Okay, what do you want to tell us, Mr. Greer?
Just a couple. Yep, there you go. Because if you don't talk on the mic, it's going to holler at you.
Can I say I recuse myself now?
Yeah, let the record reflect that Commissioner Okie has recused herself from this application because she also lives at 147 Loomis Street. Mr. Greer?
We are putting an application to demolish the barn, as you said, and replace it with a new barn because the existing barn is about ready to demolish itself. And so before our equipment and animals are crushed, we wanted to do it safely. We've put in a slight change to the size of the existing building just to accommodate our animals a little bit more than they have right now. It's slightly closer to our pond, which Cameron has been out and surveyed. I believe we should have no issues with what we have there. The only thing we have to add is a silt fence prior to construction and demolition.
Okay.
Yep,
Cameron?
so I met with Sue out on the property, and we discussed the plan. There is silt fence proposed, and that would just be installed prior to any work being done. And I would just recommend that additional silt fencing and other materials to repair or replace damaged silt fence be kept just somewhere on site ready to install in case of issues with weather or anything like that. But other than that, I don't really have any major issues or concerns with the project. While not exempt in and of itself, as it's a creation of a structure, it is for agricultural uses. So, I think the project, because it's replacing an existing barn that's apparently ready to fail with just a slight expansion for increased storage of farm animals, hay, and other farming related equipment. Again, I have no real issues or concerns with the plans.
So it's the increase in the the slight increase in the size of the barn that brings it a little closer to the pond? Is that what I am? You're not moving the building, you're just expanding it, so it ends up being.
Right, the existing barn it will be removed, and the new barn will be put right on top of it, but it's slightly bigger, so it's, by that nature, it's going to be a little bit closer.
Okay.
But it's basically going to occupy the same exact area, but just a little bit bigger.
Is this a man-made or a natural pond?
Man-made.
Yeah, I mean, the pond has been there for many years, but it wasn't originally,
It was man-made. It is spring-fed, but it's a man-made pond. It's been there 100 years.
It's a farm pond that some farmer created.
Exactly.
Yeah,
Correct.
yeah.
before you owned the property.
It's fed by underground spring,
Yes.
not a,
Both. There's both. It captures the runoff from Loomis Street down. We gave a right to drain into that pond to our neighbor. They redirected water that was coming from the Heather Lane project. It entered onto their property, crossing Loomis Street, and then it was discharged onto our driveway, roading our property. So years back, we gave that homeowner the right to drain onto our property, where that then discharges into the pond. And then we also have recently developed 157, which is also water that gets discharged, and that also is some of that water gets discharged into the pond. So there's a combination of springs that are surface that run into the pond, and then there's springs that are in the pond itself. So there's multitude of sources of spring water fed into the pond. It's got a dam that controls the elevation, and it discharges out the back of the dam, which then goes down into the Dismal Brook. So it's all kind of controlled that way. And we do have a number of sections of silt fence on hand, so we'll be able to make any ongoing repairs if needed, should our silt fence fail. But
Any more questions?
anybody up for some construction?
Got plenty of it, to do for myself.
Yes, I'm sure.
I move that we accept this permit.
second.
Second, further discussion? All in favor?
Aye.
Opposed? Abstentions? Okay.
One last comment. I just would like to thank all of you for all your patience through the vessel project.
Thank you.
It's not over.
Yeah,
No, it's not.
it is not.
It's one of the reasons God created martini. Okay, we're not done yet. Sit down.
No, we still.
It's agent reports and correspondence. What's the latest and greatest on 371 North Granby Road?
Oh, boy.
Yeah, so at the last meeting, I presented a photo that was taken the day of the meeting, March 13th. And there were some large ruts in the upland review area beyond the storage area. Essentially, that was what appeared to be from moving some of the equipment that was back there. And I asked that be repaired and, was sent to not the applicant, but the property owner and or, his counsel or representatives. So that was sent to them, and Abby and I visited the site today, April 10th. The ruts were still there, had not been repaired. Ryan Garco, one of the property owners, was present at the meeting and said that he will get it done within a week, weather permitting, and I told him that I will re-inspect in 2 weeks, given that information, rather than the monthly that has been going on, just to follow up on that, see if that actually does get repaired. Other than that, there has been no update. They are still within their previously approved. Yes, in the back. The purpose of wetland concern, they are still in that that enclosed space, 50 by 70 feet or whatever it was that was approved, 70 feet off the the back of the.
So Wetlands is responsible for the back end of the property and
Yes.
P&Z is responsible for the front end of the property.
More or less, yeah.
Yeah, but don't they have to go back for a site plan modification to expand?
Well,
that
they
area?
did.
Yeah.
Yes.
They did.
Yeah.
That's what I was going to ask Abby.
So that's pending, public hearing is on April 23rd.
There you go.
Planning and zoning.
Public hearing, April 23rd.
Mark your calendars for another public.
So, okay. So you're going to report back at the next regularly scheduled meeting?
Yes.
Right? Okay, 128 Simsbury Road, the Friends of Holcomb Farm. What are we doing there?
Yep. So that was a project to make repairs or an application to make repairs to an existing outlet structure on a farm pond. And so the applicants applied for it as an agricultural exemption under section, I should have written it down, I believe 4.1A of the Granby and wetland regulations. I know it's section 4, but so in that exemption, it does say maintenance of and other farming practices and maintenance of farm ponds less than 3 acres. This pond does fit into that description. It is used actively for agricultural uses, and so this is just kind of general maintenance to remediate the pond drainage and square things away there. In addition, they are looking to the Friends of Holcomb Farm are looking to improve habitat there, and so I suggested that they contact a herpetologist or wetland scientist who can better speak to that than I. And so they said they'll look into that, and they'll look into checking with NRCS for other projects that they may be wanting to do in the future. So that's the USDA Natural Resource Conservation Service, and they were, I believe, the ones who had originally put in the farm access road on that property. And so I suggested if they want to do anything to the road or around the road in the future, that they check with them first to make sure that that's not in violation of anything that they got going on. Other than that, I checked in with the wetland chair and vice chair, and they both agreed to rule the farm pond drainage remediation an as-of-right activity. I did write it down. Section 4.1A of the Granby Inland Wetlands and Watercourses regulations. So I signed off on that. And so this is just me sort of reporting to the commission about that.
Great. Any questions? All right. Any commissioner reports and/or correspondence? Hearing none. Motion to adjourn, please.
So moved.
Second.
Don't all speak it. We have a first by Fred, a second by Arel. All in favor?
Hi.
Opposed? No.
Opposed can stay.